Good morning. Recognizing a quorum of commissioners, I'll call the July 28th, 2025 meeting of the Cannabis Control Commission to order. This meeting is being held pursuant to Chapter 2 of the Acts of 2025 and is being recorded. Commissioners Concepcion, Roy, and myself are participating in today's meeting. All votes taken today will be by roll call. We have a full agenda that I will generally summarize. We will start with opening comments from commissioners before we proceed to staff license recommendations. There are 2 change of ownership recommendations, 17 license renewal recommendations, 2 provisional license recommendations, and 1 final license recommendation. 1 responsible vendor training renewal license. There are 3 items in the commission discussion and vote section today. We have an open meeting law complaint update, discussion and review of draft regulations and policy questions, and a regulatory timeline discussion. I will ask that commissioners wishing to comment or ask questions during any part of the meeting raise their hand to be recognized. With those initial comments, I'll turn things over to my colleagues for any comments or updates. Commissioners, we'll go in alphabetical order. I'll give my comments last, and I will start with my colleague, Commissioner Concepcion.
Thank you, Chair. I will be remarkably short and sweet. Good morning. Good morning to you all. I know we have a lot on our plates today, a lot of discussion around social consumption, so I will not take up much time. But good morning. Glad to be here. Excited to get to work.
Thank you, Commissioner. Commissioner Roy.
Good morning to my colleagues and to the entire team and to everyone listening. And I too will be brief. I just want to quickly acknowledge and recognize the milestone we announced recently that adult sales have surpassed $8 billion in gross sales. I want to take the time to acknowledge the work that the staff does to regulate this industry and recognize this achievement, and also that so much work has been done and there's more to do. We've tackled in the past the micro business license type, the delivery operator and courier. We're in the process of looking at testing the medical regulations, and today is all about social consumption. So again, I just want to acknowledge this milestone and achievement and thank everyone involved. Thank you.
Thank you, Commissioner. I will also be brief. Thank you, Commissioner Roy, for highlighting that milestone that we reached. Also to extend my thanks to our incredible team who work hard to regulate the industry as they are directed to do. And also I feel you're responsible in helping thousands of people across Massachusetts work in this new and exciting industry. We have a lot to get through today. We have a number of licensing actions before we get into a good deal of discussion around our social consumption and other new regulatory changes. I'm hoping we can get to a vote on this draft so we can formally kick off that promulgation process. I will plan on taking a lunch break at 12:30, just for about 30 minutes. Certainly, if any of my colleagues or members of our team need a break, please let me know. And with that, we will move on to our licensing work. And I think Jamie Wakefield is joining us. Good morning, Jamie.
Good morning, everyone. Thank you for having me again. Great to see everyone.
Great to see you. All right, we begin, I believe, with staff recommendations on changes of ownership.
Yes, there are 2 changes of ownership and control requests for consideration today. The first licensee is Beacon Compassion, Inc., doing business as Uptop. They are seeking a change of ownership and control over 1 adult use license and are requesting to add 4 individuals and 1 entity. Additional information is contained within the executive summary for the Commission's review and consideration. Commission staff have reviewed the application for compliance with applicable laws and regulations and are presenting it for the Commission's review and vote.
Okay, just bear with me for just a second, Jamie. Thank you for that. Okay. Thank you, Jamie. Again, this is a change of ownership for Beacon Compassion, Inc. Are there any comments or questions from commissioners? Seeing none, I would seek a motion to approve the change of ownership for Beacon Compassion, Inc. Do I have such a motion, Commissioner Concepcion?
So moved.
Do I have a second, Commissioner Roy? Motion been made and seconded. Any further comments or questions? Seeing none, I will do a roll call vote. Commissioner Concepcion,
Aye.
Commissioner Roy,
Aye.
and Commissioner Stebbins votes aye. 3 in favor and none opposed. Okay. Jamie, you can go to the next.
Okay, the licensee here is Pharmacanis, Massachusetts, Inc., doing business as Verilife. They are seeking a change of ownership and control over 5 adult use licenses into medical marijuana treatment center licenses and are requesting to add 1 individual. Additional information is contained within the executive summary for the Commission's review and consideration. Commission staff have reviewed the application for compliance with applicable laws and regulations and are presenting it for the Commission's review and vote.
Okay. Thank you. Commissioners, any questions on the change of ownership for Pharmacanis, Inc.? Being none, I would seek a motion to approve the change of ownership for Pharmacanis, Inc. Do I have such a motion, Commissioner Roy?
So moved.
Do I have a second, Commissioner Concepcion?
Second.
Motion been made and seconded. Any further comments or questions? Seeing none, I'll do a roll call vote. Commissioner Concepcion,
Aye.
Commissioner Roy,
Aye.
Commissioner Stebbins votes aye. 3 in favor, none opposed. All right, we will move on to staff recommendations on renewal license.
There are 15 adult use renewals and 2 medical marijuana treatment center renewals for consideration today. Additional information is contained within the executive summary for the Commission's review and consideration. Commission staff have reviewed the applications for compliance with applicable laws and regulations and are presenting them for the Commission's review and vote.
Thank you, Jamie. I don't believe any commissioners had any conditions to attach for any of the renewals. So I would seek a motion to approve the slate of renewal licenses 1 through 17 that's included in your board packet. Do I have such a motion, Commissioner Concepcion?
So moved.
Do I have a second, Commissioner Roy?
Second.
Motion been made and seconded. Any further comments, questions? Seeing none, I'll do a roll call vote. Commissioner Concepcion,
Aye.
Commissioner Roy,
Aye.
and Commissioner Stebbins votes aye. 3 in favor, none opposed. All right. Next up are 2 provisional licenses.
Yes, the first applicant is Charlestown Cannabis, Inc., doing business as Charlestown Cannabis. The proposed location is 31 Cambridge Street, Unit 1 in Boston. They are seeking a marijuana retailer license and the applicant received expedited review. Additional information is contained within the executive summary for the Commission's review and consideration. Commission staff have reviewed the application for compliance with applicable laws and regulations and are presenting it for the Commission's review and vote.
Thank you, Jamie. Yeah, excited to both of our provisional licensees, if I'm not mistaken, are both SCP. I think one of them was a participant in our first cohort, so happy to see them reaching this stage in the licensing process and their business opportunity. I don't believe there are any conditions for any of this provisional licensee. So I would seek a motion to approve the provisional license for Charlestown Cannabis, Inc., number MRN 285114. Do I have such a motion, Commissioner Roy?
So moved.
Do I have a second, Commissioner Concepcion?
Aye. Second.
Or-
Second and ditto to what you said about this particular application. I did recognize this is someone from the first cohort, so kudos and congratulations to you.
Motion been made and seconded. Any further comments or questions? Seeing none, I'll do a roll call vote. Commissioner Concepcion,
Aye.
Commissioner Roy, and Commissioner Stebbins votes aye. 3 in favor, none opposed. Congratulations to Charlestown Cannabis, Inc. All right, Jamie, the next one.
The applicant here is Rivers Leaves of Natural Healing, Inc. The proposed location is 42 Main Street in Maynard. They are seeking a marijuana retailer license, and the applicant received expedited review. Additional information is contained within the executive summary for the Commission's review and consideration. Commission staff have reviewed the application for compliance with applicable laws and regulations and are presenting it for the Commission's review and vote.
Thank you, Jamie. I did not have any conditions for Rivers Leaves of Natural Healing, Inc. Seeing none, I would entertain a motion to approve the provisional license for Rivers Leaves of Natural Healing, Inc., number MRN 285254. Do I have such motion, Commissioner Concepcion?
So moved.
Do I have a second, Commissioner Roy?
Second.
Motion been made and seconded. Any further comments or questions? Seeing none, I'll do a roll call vote. Commissioner Concepcion,
Aye.
Commissioner Roy,
Aye.
and Commissioner Stebbins votes aye. 3 in favor, none opposed. And congrats to Rivers Leaves and Natural Healing, Inc. All right, we will move on to staff recommendations on final licenses. We only have one final license on the agenda. Jamie, you want to talk about this one?
Sure. As you stated, there's one final license recommendation. Commission staff have reviewed the application for compliance with applicable laws and regulations and are presenting it for the Commission's review and vote.
Okay. I didn't receive any conditions for this one or any comments or questions from my colleagues. Seeing none, I would seek a motion to approve the final license for Ignited Culture, Inc., MR 284438. Do I have such motion, Commissioner Roy?
So moved.
Do I have a second, Commissioner Concepcion?
Second.
Motion been made and seconded. Any further comments or questions? Seeing none, do a roll call vote. Commissioner Concepcion,
Aye.
Commissioner Roy,
Aye.
and Commissioner Stebbins votes aye. 3 in favor, none opposed. Congratulations and best of luck to Ignited Culture, Inc. All right. Jamie will quickly move on to staff recommendations on responsible vendor training renewals.
Okay. There's one responsible vendor training renewal for consideration today. The licensee is DSB Worldwide, Inc. They're seeking to be renewed for an additional 2-year certification to provide basic core curriculum training in the responsible vendor training program. Since their original certification date, they have provided instruction for 82 marijuana establishment and medical marijuana treatment center agents. Additional information is contained within the executive summary for the Commission's review and consideration. Commission staff have reviewed the application for compliance with applicable laws and regulations and are presenting it for the Commission's review and vote.
Okay. Thank you, Jamie. Any questions on this RVT renewal? Okay. Seeing none, I would seek a motion to approve the responsible vendor training renewal license for DSB Worldwide, Inc., RVR 453156. Do I have such a motion, Commissioner Roy?
So moved.
Do I have a second, Commissioner Concepcion?
Second.
Motion been made and seconded. Any further comments or questions? Seeing none, I'll do a roll call vote. Commissioner Concepcion,
Aye.
Commissioner Roy,
Aye.
and Commissioner Stebbins votes aye. 3 in favor, none opposed. All right. We will move on to the first item under commission discussion and votes. Well, we have our general counsel here with us. Mike. The first item under commission discussion and votes is a open meeting law complaint update.
Good morning, commissioners. And before we get to the main event here, I just wanted to take a few minutes to talk to you about an open meeting law complaint that we received and discuss with you proposed response to that complaint. I had put together a couple of slides. I'll quickly go through them. I don't know if they're being shown or not.
I believe we're having a technical issue, so they're not going to come up on the screen.
So I'll go through my slides here. So the complaint was received on June 25th by email. It alleged an OML violation for failure to post notice of the State of Cannabis event that was held on April 29th of this year. The complaint went on to posit that failure was to post was a deliberate attempt to hide the event from public scrutiny, and on that basis suggested an intentional violation of the open meeting law. First off, at the outset, I wanted to just highlight that the complaint is not timely. It was filed more than 30 days after the event, so under the guidelines for OML complaint filing, it is untimely. But I did want to also discuss a little further about the suggestion here that that the commission was trying to hide the event from public scrutiny, and did want to highlight a number of the actions taken by the commission in the run-up to the event and then subsequent to the event to get the word out about the event. As you're aware, commissioners, there is a website that we have on our webpage that is dedicated to the State of Cannabis event. It's at masscannabiscontrol.com/state of cannabis. Prior to the meeting, prior to the State of Cannabis meeting, some meeting materials and discussion topics were published on the Commission's website there at the link that I just told you about. And the actual, the PowerPoint presentation that was used during the event was added on the morning of the event. And then the recording was added on June 26th of this year. Now, on the morning of the event, the Commission posted on its Facebook, LinkedIn, and X accounts some additional details about the event, including the room number, as well as names of legislators who would be present. In addition, the event was highlighted on the Commission's Facebook, LinkedIn, Instagram, and X social media accounts on May 6th, 2025, with a link to the Commission's webpage. And then lastly, the recording of the event was published on the Commission's YouTube channel on May 15th, 2025 I expect that the event will continue to be highlighted and publicized throughout the course of communications coming up in the future from the Commission. So, just wanted to discuss that, through these actions, the Commission has demonstrated that it was not trying to hide the ball regarding the event at all, and did take a number of steps to, in fact, highlight the event for the public. So on that basis, what I'm going to suggest here and request approval for is to reply to the complainant and to the Division of Open Government, highlighting the things that I just told you about, to suggest and get the point across that there was no deliberate attempt here to evade the strictures of the OML and highlight all the steps that the Commission has taken to highlight the event.
Any questions for the JC?
I have a question.
Commissioner Concepcion?
I just want to make sure I have the timeline correct, because there was a lot that happened between the actual event and the complaint. So the complaint was filed in June.
Correct.
We originally posted materials about the event on April 14th. The State of Cannabis occurred on April 29th. We posted on our social media sites about the event on May 6th. And then on May 15th, the entire video of the event occurred. This is all prior to a complaint being filed.
That is all correct. Yes.
Thank you.
Awesome. Okay. Thank you, GC. Appreciate that.
And Ms. Tracy, if I could just ask for a motion on that.
Yes. Just so we respond to the complaint, is there another step in the process? Does this complaint then get forwarded to the Attorney General's office, or is that left up to the complainant?
Well, so the next step would be for us to respond. We would respond to the complainant and the Attorney General's office simultaneously. So they'll both get the response.
Okay.
I have another question.
Sure.
I guess my question is because there's a few different prongs here. Obviously, it wasn't filed in time, so it's not a timely filing. I guess my question is, what is the response when it is the idea to be succinct and just saying that, or to also include all the additional information about the available information that was made prior to the complaint?
So in response to the question, if I may, I can share. It will be all of it.
Perfect.
So both the timeliness of the complaint as well as the additional details that I outlined here.
Okay. Thank you.
Commissioner Rico.
Just quickly, is there anything we need to do differently next year?
Yeah, if I may, Acting Chair. I think we will, when the event comes around next time, we will have a robust conversation about whether this needs to be posted or not, and in advance we'll have a better idea of, who will be in the room at whatever times, and depending on that information, we may decide to post.
Because we're not deliberating there. We're not voting on policy there. So is it technically a meeting?
If I may, Acting Chair. Whenever a quorum of the body is present in one location, and topics under the jurisdiction of the body are being discussed, the AG has taken the position that that is considered a meeting that, would have to be posted. So want to be mindful of their requirements.
Thank you. So in light of that response, so we posted a social media post on April 14th. What happened on April 14th?
Yeah, if I may, Acting Chair. So the commission has had a State of Cannabis webpage on its site.
Yeah.
And we posted some of the materials in advance of the event on that site. So that was done on April 14th. The event was April 29th.
Okay, but not like how we normally post for today's meeting. We did it somewhat differently.
That is correct.
Oh,
yes. So we didn't, that's right.
Thank you.
Just go ahead, Commissioner.
You can go first anyway.
Yeah, the updates are made. It's great that we have, obviously, this is an event that we all enjoy participating in. We all arrive with kind of pre-prepared presentations about how the meeting is guided. Obviously, our team participates as well, making presentations about their individual departments or agencies' work. Did we have a discussion about it in a public meeting? We would also flag this as coming up. So not just kind of the web-based and social media platform notifications, but did we talk about it? And also, we regularly list the Director of Governmental Affairs kind of activity report at every public meeting. I don't know if that's documentation again. Also, that would have been part of a public board meeting packet that would have obviously highlighted the outcome of that.
Yeah,
there's additional information to go back to look at and include.
We will certainly double check, Acting Chair, and I will add that at I think the meeting before the event, as part of the upcoming meetings, there was an indication of a meeting coming up. So this would have been listed on that at that time. But we will make sure that all that stuff is included in our response.
Thank you, Commissioner Concepcion.
Thank you. I wanted to make a note. Kajal, thank you so much. GC, this is the way this is laid out is very clear. So I appreciate that. Anytime you can make things really, really clear and succinct when it comes to legal things is so helpful. I wanted to make a comment about the state of cannabis in general, because based off of this, there seems to be some, I get the impression that there's a little bit of confusion around the intention. So I wanted to sort of clarify what my intentions were in creating the state of cannabis. And it wasn't for commissioners. People hear from us every time we're at a public meeting, when we're out in the public and we are public facing, but the state of cannabis is built around the idea of staff. Staff being able to convey the work that they do and what actually happens internally at the Cannabis Control Commission. So the bulk of the state of cannabis is not actually about the board members of the Cannabis Control Commission, but the heads of different departments, the breakdown on each of the departments and what they actually do. So I just wanted to clarify that. And I also wanted to make a statement that because the information that's given during those state of cannabis events are so valuable, it might make sense for us to consider having it posted live. So there's a live feed that people can actually view if they're not able to come to the State House. But it's always open to the public. It's in a public space. That's why we have it at the State House. I've heard during the development of the state of cannabis, that the State House was a great location because it's so accessible by both public transportation and people who might be working around that area as well. But I just wanted to clarify that the state of cannabis is not intended to be focused on the members of the Cannabis Control Commission, the board. It's about the work that's happening internally and making sure that we're highlighting those people who are actually doing a ton of work here, and then understanding what goes into the process. So I just wanted to make that comment.
Thank you, Commissioner. Commissioner, go ahead. Okay. All right. If there's no other topics or questions or comments, I would seek a motion to direct the general counsel to respond to the open meeting law complaint consistent with the GC's presentation at today's meeting. To have such a motion, Commissioner Concepcion.
So moved.
Do I have a second, Commissioner Roy?
Second.
Motion been made and seconded. Any further comments or questions? Seeing none, I'll take a roll call vote. Commissioner Concepcion.
Aye.
Commissioner Roy.
Aye.
And Commissioner Stebbins votes aye. 3 in favor, none opposed. All right. Why don't we take a short break before we jump into the regulatory discussion? 10 minutes, I think would be appropriate. Let's take 10 minutes. We'll reconvene at 10:55. There we go. All right. Hey, Betsy, we're okay. We're resuming. All right. Okay, we're resuming our July 28th, 2025 public meeting. And we'll move on to the next item, which is discussion and review of draft regulations and policy questions. This is for a vote. This is revisions to 935 CMR 500, 935 CMR 501 regarding social consumption, and is and some additional policy topics that have come up through our extensive conversations on these regulations in previous meetings. So we've been through the regulatory language change for social consumption. I'm hoping today we can focus on some of the new language since our last version, especially with respect to agent registration. Incident reporting is new, has some changes to it. The topic of wasting has some recommended changes to it, as well as sale of shelf-stable, non-infused edible items, and specific areas of focus that I hope all of my colleagues have had the opportunity to identify since our last meeting or your review of the current updated version. Keep in mind that this is a draft and we are inviting formal public comment through the promulgation process, and we will also be scheduling, as required, an in-person public hearing. An important message I want for all of us to share is that this is a draft. We are looking for input, and our regs have the opportunity to be changed. I think a great example of that was our discussion in the last round with respect to delivery, that we made some last-minute changes to extend relief to ITLs and their related delivery work. We will obviously have another opportunity to go through the final version line by line, as we have done in the past, after the public comment period is closed and we seek a final version. By the way, I also know that we have posted a meeting for tomorrow, just in case we need it. And our DGC and our legal colleagues are making edits and changes in real time. So hopefully if we vote today or tomorrow, we can file with the Secretary of State on Friday. We'll focus on following sections and look at some of the new edits and additions to the regulations. Again, if my colleagues have any sections of interest outside of these sections, we can address them. But we'll work through 500.002 definitions, 500.005 fees, 500.029 registration and conduct of laboratory agents, 500.030 registration of marijuana establishment agents, 500.050 marijuana establishments, 500.101 application requirements, 500.103 licensure and renewal, 500.104 notification approval of changes, 500.105 is general operational requirements for marijuana establishments, 500.110 security requirements for marijuana establishments, 500.130 additional operational requirements for marijuana product manufacturers, 500.140 additional operational requirements for retail sale. The big one, 500.141, the additional operational requirements for social consumption establishments, and 500.145 additional operation requirements for delivery of marijuana, marijuana products, marijuana accessories, and marijuana establishment branded goods to consumers and is permitted to patients and caregivers. With that, I will start off with unless my colleagues have any comments or questions that they want to raise before we get started. Commissioner Roy, go ahead.
Thank you. Actually, this is more process. I just want to make sure we're all working off the same document. And Mike Baker, you had emailed the latest. Is that what we should be working off of? The email you sent? Okay, just want to make sure we're all on the same document. Thank you.
Thank you, Commissioner. Good reminder. All right. I'll hand it over to our Deputy GC. We'll start off with some of the definitions section. Any points that my colleagues wish to raise with definitions, but Deputy JC, if there are any things you want to point to us about?
Sure, thank you, Mr. Acting Chair. I just want to, at a high level, point out the newer definitions that were not included in the last draft so that everyone is, all on the same page. So, Mr. Enforcement Counsel, actually, I think we're going to get right into this. So the first one that comes up in alphabetical order is diversion, and then subsequent to that is inversion. So diversion was not defined beforehand. So throughout this draft, we had marked up diversion and inversion where they arose, but I believe Enforcement Counsel wants to make an amendment to that.
Okay, so the diversion definition is on page 6. Diversion, I believe, is on page 10. So why don't we start, if everybody can find the language on diversion on page 6 in Enforcement Counsel. Go ahead.
Thank you, Acting Chair. We definitely, I think, appreciate the addition of these definitions. We did want to make just a friendly suggestion on this. So as written, the definitions are very specific, and I think a more general definition might aid in terms of enforcement as well. So rather than the language that appears in the draft, our suggestion would be diversion means an intentional or the intentional removal of marijuana or marijuana products from the regulated market for diversion. And then I have a suggestion on inversion as well, but I think we can take them one at a time.
You want to drop those in that language?
Yes, and as I mentioned before too, IT is helping me out with my computer, so I'm on my phone right now, so I'll
All right.
take that out.
All right. No worries.
Might take a while.
See how fast your thumbs are. Just
Acting Chair.
Commissioner Concepcion.
Thank you. I think Enforcement Counsel, I think you're thinking of language that might tackle one of my concerns. It was because the definition here for diversion accounts for product that's brought into the illicit market, but it doesn't count for product that's taken unlawfully and used for personal consumption or someone else's consumption. So I think what you're thinking through would answer this, but I just wanted to say that for the record.
Yes, and Acting Chair, Commissioner Concepcion, that's one of the issues that we were trying to tackle with this is that because it specifically references the illicit market, exactly somebody taking it, and we have seen instances of folks taking or diverting product for personal use. This would, the more general definition would get at that or would encompass that as well.
Thank you.
Commissioner Roy.
Thank you, Acting Chair. EC, could you please restate it, the definition proposed? I know you're putting it in the chat, but can you just say it again?
Yes, of course. So diversion means the intentional removal of marijuana and marijuana products from the regulated market.
While we're looking, well, I know you're working on that language and dropping into chat for all of us. Why don't we move over to, you also had some changes to the definition of inversion.
Yes, thank you, Acting Chair. And so similarly, with the definition of inversion, we wanted to suggest inversion means the unauthorized insertion of marijuana or marijuana products cultivated or produced by an unlicensed individual or entity into the regulated marketplace.
Commissioner Roy.
You say unlicensed, EC good and unlicensed entity, but I've heard of anecdotally instances where, let's say, across the country where cannabis could be at a cheaper price. So they're licensed in that, they could be licensed in Oregon and somehow their product is making its way to Massachusetts. So technically they're licensed. So there's a little bit of a loophole in this definition. I think we need to, maybe we want to say Massachusetts licensed because they could be coming from another state where they are licensed.
Yes, thank you, Acting Chair, for me. Thank you, Commissioner Roy. So I do, so one thing that we wanted to highlight is, one, we're identifying that it's unauthorized insertion because there are instances where, say, a new cultivator is adding clones into metric or something along those lines. So they reach out to us just as a matter of practice to get that authorization. When we're talking about out-of-state entities, I mean, I definitely hear your point. We might be able to amend this suggestion to say licensed by the Cannabis Control
Yeah,
Commission,
that's all.
something along those
Just to
lines.
straighten that part up.
We have in the chat, new language for diversion. Again, recommended amendment here is to define diversion as diversion means the intentional removal of marijuana and marijuana products from the regulated market. As a question would be, are we looking to specifically address it about the Massachusetts market, or is that just understood because we're just giving a general definition to be included in our definitions, or do we need to make it specific to Massachusetts?
I think it is obvious, Mr. Acting Chair, but it never hurts to be more specific for this. So if you wanted to say from the regulated market in Massachusetts, that would be fine, or from, yeah, I think that would be appropriate.
Look to my colleagues, do we have any issues with adding in Massachusetts, or Commissioner Concession?
No, I don't have any issues with that. I think I did like the language though, that within the definition that was provided in the draft, it references the Cannabis Control Commission. So I wonder if we can combine some of the language that we have here with a suggestion. And then the other thing I wanted to add or ask, I liked the addition of unauthorized that you use in the inversion definition. And I wonder if that can also be utilized here as well, because diversion means the intentional removal. So instead of just intentional, means the unauthorized or intentional removal. I just wonder if that might cover more bases.
I agree with you. I agree.
Acting Chair, if I may just respond, and thank you for the suggestion, Commissioner Concepcion. I think that would make sense, and just briefly conferring with Director of Investigations, as well as the Chief of Investigations and Enforcement, there are potentially instances where there would be an authorized removal. So we're talking about waste or something along those lines, or other means that are through our regulations. So I think by adding unauthorized, that would make sense here too.
And I had another question,
Sure.
and it was around the term intentional. Because do you need to have that state of mind? You need to be intentional in order for it to be considered diversion.
So, excuse me, if I'm looking just back. So for diversion, I mean, I think we suggested intentional there, just in the event that there was a mistake or something along those lines. There could be an innocent explanation for some of those if we wanted to take out intentionality of it. I mean, I will say too, this is the definition. So we have in our regulations, there are regulations such as employees or agents have to sign a statement saying they will not engage in diversion. So here, this is where we are kind of creating the ground rule for that. So if we want to add intentional in, or if intentional remains in the definition, then we would impart that element into our kind of prosecution or enforcement of those. So just as we're kind of thinking this through, I think intentionality could be helpful as we're kind of looking at that, but I definitely am open to kind of general suggestions, or if the board wanted to add it by a minute.
I wanted to hear more from the team, just to understand, you know, so what happens if someone were to unintentionally, you know, take product? Do we need intentionality? So, you know, kind of tell me what the practice is and what makes the most sense.
Sure. Thank you, Commissioner. Yeah, so it would fall under incident notification, so it would be something that the licensee would be required to let us know of. It should be something that comes up in the required inventory reports, either monthly. They're required to do monthly as well as comprehensive annual, but most of them do kind of cycle counts and weeklies as well. So they would be required to let us know within 24 hours. We would investigate it appropriately. If it turned out to be something, I can't really think of how someone would bring something home without knowing, but we would certainly make sure it was reported to law enforcement, look into it, and whether it was in line with their SOPs as well.
Commissioner Roy.
Thank you. I'm going to just follow up on Commissioner Concepcion with intentionality. That's a high standard of proof, where unauthorized is just unauthorized. And if it was by mistake, I think it's a harder burden of proof for the commission to prove a state of mind. But unauthorized is clearly unauthorized. And if it was a mistake, we could still address it. I just think we're putting a higher burden of proof on us with that word. And I think just unauthorized, to Commissioner Concepcion's point.
There you go.
Thank you, and definitely appreciate this discussion too. So just in conferring with the chief briefly, we're also thinking that we might be able to say, or one suggestion could be unauthorized or intentional, just to kind of separate that. If we can show the intentionality, that might be helpful too, to show that it is kind of a bad act. And as we're looking at this too, there could be instances like a director of investigations had indicated that really more amount to like an inventory issue, as opposed to specifically diverting product from the regulated industry for kind of illicit marketplace, personal use, et cetera. So maybe adding the or would allow a little bit more flexibility in there as well. Mhm. And the chief is helping me out by adding
Teamwork.
He's doing some work for you. This is kind of flipping the script here. Right. So we definitely want to add the word unauthorized under the diversion definition. Unauthorized or intentional. Is there?
And we were going to add, we were going to harmonize it with the words Cannabis Control Commission, right?
Right. Do we need to add intentional under, or intentional under the inversion definition? Want to add or intentional under the inversion definition? Or is it much clearer on the inversion side of the spectrum?
Yeah, acting chair, I think I would definitely welcome my colleagues if they have any other thoughts on there, but there could be intentional insertion that would be authorized. However, though, I think it doesn't necessarily need to be intentional on the inversion side of things. We're really more talking about whether it's been authorized by the commission. So I don't think it's necessary on the inversion side of things. For diversion, though, that is actually pulling regulated product out of the marketplace. So I think that might be intentionality is more appropriate for diversion, and it may not be necessary for inversion.
Oh, if I can maybe come back to a verb, diversion. Diversion, no.
Skinny you shot.
Well,
Mr. Argent.
I'd like to win the lottery, guys.
Took into account the conversation, tried to replicate it in this draft.
Okay.
So it reads, diversion means the unauthorized or intentional removal of marijuana and marijuana products from the Cannabis Control Commission's regulated market.
Between marijuana and marijuana product, or
You can divert marijuana, or you can divert marijuana products, or it can be both. Like this.
Amended on the chat.
Diversion means the unauthorized or intentional removal of marijuana or marijuana products from the Cannabis Control Commission's regulated market. Commissioner Rocca.
will these be mirrored in 501?
Yes.
Thank you.
So any comments or questions or friendly amendments to the new version of diversion. You all set with the version? Okay, all right. Deputy GC will incorporate that language. Seems to be consensus. And inversion, again, means the unauthorized or intentional. Do we want, I think we said we wanted to add or intentional under inversion.
I have a comment for that.
Sure.
I don't,
Go ahead.
this is I believe we should not include the term intentional, but that's if what I'm believing is correct. So I'll say this out loud. Very high level. Is hemp, are hemp products considered marijuana products? Because we do permit the sale of hemp products within our regulated retail places. So I wouldn't want to say intentional here because that is intentional. The sale is intentional. It would be a marijuana product, but it's not regulated by the CCC. Do you understand what I'm saying?
Yes. Yeah, Acting Chair and Commissioner Concepcion. Under our definition of marijuana or cannabis, hemp is explicitly excluded from that. But I do agree with your overall sentiment that including intentionality is not necessary for the inversion piece.
Commissioner Roy, you all set on inversion? Okay.
Do we have the final wording? I just want to
Thanks. Inversion means the unauthorized insertion of marijuana or marijuana products cultivated or produced by an individual entity not licensed by the Cannabis Control Commission into the regulated marketplace.
One more question.
Go ahead.
Just because I'm seeing that there's a little slight variation. In diversion, we're saying market, in inversion, we're saying marketplace. Should probably mirror the terms that are being used. Market. Yeah.
Edit.
Just take place off of market in the inversion definition. Okay. All right. Deputy GC, what else do you want to cover?
Thanks. I just have two more definitions that are new for this draft that I'd like to review.
Okay.
They're both on page 7. They're both with an E. So enclosed space is a definition that we wanted to ensure was added to this draft because of our indoor smoking consumption requirements. Basically, if it's an enclosed space that's going to have smoking, there's a number of things that come with that under 141.10. And so that's why we defined enclosed space as it is.
Okay. That definition is on page
7.
I
can read it.
Any thoughts or questions from my colleagues on that? I have a question. So when you think of the second part of that, such barriers may be removable, but the designated area shall not be considered an enclosed space when the barriers are removed.
You can
kind of give me an example of.
Absolutely. I think most folks will understand that when it gets nicer out, bars and restaurants will open their doors, large windows. That would then potentially not be an enclosed space any longer if that was the case for our establishments. So that's the consideration for that second line. And everything relative to outdoor smoking consumption areas, we did try to model off of existing regulations for smoking relative to cigarettes to model them and not recreate the wheel there. So you will see some similarities, especially in 141.10 and 11, where we do try to model it off of, again, existing regulations from other agencies.
Commissioner Rick,
Just a question, did we purposefully leave out ceilings? I know we have other barriers, but was that an intentional omission? So some ceilings are retractable.
Yeah, I'll have to double check with my associate general counsel on that. I think that ceiling might indicate something legally, so let me just double check before.
And you'll get back
I'll
to
get back
us.
to you.
Okay, thank you.
Attorney Baker, I have a question. In the definition, we also have the definition within the definition. In the first two sentences where it says, or exiting the enclosed space, can we just say area?
Sure, or space, just.
Space, yeah.
Thank you, Chief.
What's the other definition? you want?
Yeah, so just below that, event plan is also a new definition. So to kind of back up away from just the language here, this draft, we wrestled internally with the commission on the event organizer license, as we discussed before. We reshaped it in this draft. So that's, I would say, one of the largest amendments to this package is now, instead of having the permitting process under the event organizer license, we go through the municipality, similar to how the ABCC does their daily liquor licenses. So again, we didn't have this in the last draft because event plan wasn't a thing before. It was the temporary consumption permit. So the way that it will function throughout this draft is folks will have to go through the municipality, get the approval, and then submit the event plan subsequent to that approval on the local level. So again, that's one of the larger amendments in this draft. And so if the public could take a look at that, that would be something I'd like to point out.
Any questions on the event plan definition? Anything else you want to cover under definitions? Okay, I have just, sorry, Commissioner Rankin.
I'd like to go to page 4.
Mhm.
The definition of commission delegee, which I've brought up numerous times.
Sure.
So I'd like to rework this definition. So I feel it's overly prescriptive and it's self-limiting on who we can partner with to effectuate our secret shopper program. So I would like to expand it so it could be outside individuals or agencies.
Commissioner Roy, do you mind restating which definition?
Sure, it's page 4
Mhm.
and it's the commission delegee,
Thank you.
the bottom of page 4 on the Word version. I guess if I may.
Go ahead.
So as it's written, it's self-limiting on what and whom we can partner with to effectuate secret shopper. And my question is for enforcement. Based on the current version of commission delegee, how is it possible to do identification check requirements if we are unable to partner, say, with college students, or how are we able to execute that with the current definition?
If I may, Acting Chair, Commissioner, before we go to that definition for commission delegate, Attorney Baker, I have a suggestion for us to consider. We have it here saying prepared by. Maybe we should say submitted by for
The previous thing.
the previous thing.
Yeah. You put that in the chat?
If the event plan means a document or series of documents prepared by, maybe it should be submitted by, because they're the ones that, right?
Sorry.
Yep.
It's back on page 7. So removing prepared and exchanging it for submitted.
Yes.
which is actually what they'll be doing.
Mhm.
That's right.
Okay, so then with commission delegate, okay, so let's go back to that. So Commissioner Roy, your suggestion is for us to expand on the
Yes,
definition.
I feel it's self-limiting and it limits who are able to coordinate with to effectuate this program.
So your suggestion is to include what?
So as it reads, a plain reading, it makes one think that we can only partner with other government individuals or agencies. Which is I'm not sure how we are able to effectuate 500-303 identification checks requirements. Part of the secret shopper, based on a plain reading, I can't see a scenario how we can execute that. Unless somebody can explain otherwise how we're able to do that.
Yeah, I think this one would have to defer to the legal department because the question is more about our authority to effectuate the regs, the regulations. So I'll defer to the legal department.
Thank you, Chief, and thank you for the prior amendment as well. I think that there might be a way to not change the definition, but to go into the secret shopper program and amend the language there, because commission delegee arises in the context of court and other places throughout the 300s. And so I think that we could surgically amend that secret shopper program section to exclude commission delegee and try to come up with a different language there.
Which would allow us to expand our resources.
Sure, while often not infringing on the sections in which commission delegee arises, that is, very specific for that definition.
Do you think currently it's kind of conflated the term because it's used in the like for a court delegee? So
Right.
it's really almost not appropriate where it is. There's probably better vernacular, if you will.
There's many ways that we could go about addressing this, and I think the way that you're suggesting might infringe on the existing sections in the 300s.
Okay.
Where it arises. So if really the goal of this amendment is to change it so that the secret shopper program can partner with private entities, then let's go to 303 and see how we can tweak that.
We get there. Yeah, I guess my concern is like we have this identification check proviso, right? And I don't know how we can do it based on the language of commission delegee. How do we execute that? If someone can explain to me. So I think we do, and I'd be grateful if we could tweak it within that definition. Just so it's so self-limiting the way it is now for us.
Could I make a suggestion that when we break for lunch that we convene to try to mark this language up?
And I would invite Commissioner Concepcion because she's the sponsor on the topic.
Go ahead.
Chair, if I may, because I know I don't want us to go astray of what we're doing right now. What I'm understanding from you, Attorney Baker, is that that's something that we can tackle separate to the conversation today. And that would go underneath the language where we talk about secret shopper. You're not suggesting that we make any amendments to the language of commission delegee as is right now because of what it impacts across our regulations.
As far as the definition, I would definitely suggest reconsidering that. I think I understand Commissioner Roy's approach here, but I think we can be narrow with our amendments in 303 to effectuate her goal.
So I guess what I just want to make very clear is I want us to continue with the social consumption conversation today, and let's, try to get that done today if possible. Tomorrow, that would be awesome. But then I do welcome a conversation with us to address those concerns because I do think that they're valid. But I don't want us to get sidetracked on what we're actually doing right now around social consumption.
Sure. I think if we can meet over break, maybe we could mark it up.
But I guess that's where I'm getting confused. Mark what up? Mark up
303.
To mark up
The secret shopper. Excuse me.
So that's where it's throwing me off because the suggestion is to tackle not social consumption, secret shopper today.
I think it is germane because we would want to execute secret shopper when these social consumptions are open. Under ID verification is completely germane to enforcement around secret shopper and this license type. So I do think it's appropriate.
Oh, I'm not, no doubt about that. I'm just saying today because I think we would have to tie in Chief Kamalo. We would have to tie in a few other people to make sure that what we're providing is aligned with the overall objective. And I think that would take more than a few minutes of conversation. Chief, I'll welcome your opinion on this as well.
Yeah, if I may, I don't think 30 minutes is going to be sufficient during lunch break for us to tackle 303 right now, because there's other nuanced things that we need to think about. We'd also have to include enforcement council, include TOI. I think maybe what we can do as a suggestion is, now that this has been brought up, is something for us to think about outside today's social consumption rights discussion, and maybe, we can possibly see if it's possible for us, if we have time to get into it. But I think it's more nuanced than what meets the eye. There's a lot more that we need to think about in terms of how we'll be able to tackle, what Commissioner Roy has suggested here. But, we won't be able to do it today.
Thank you, Chief. Go ahead, Commissioner.
Is it possible to get it to a point when we put this out for the public? Because what happens is, if it doesn't happen in this round, then it's months away till we tackle it again.
April would be the next timeline, just considering our next regulatory round, that's around exclusivity.
I would suggest this, and again, I apologize, you two have been working on this. So just what I'm picking up is there a sense of a tweak to make sure that whenever a secret shopper program is developed, there might be contracts or agreements with other parties, other agencies to enact that.
If I may, because this is a conversation that the secret shopper group can and will have. I don't think that it's right now. This is a concept that makes sense, but you're talking about a change to our regulations that's not been conceptualized by the legal team or anyone else here who's been doing the work. So what I'm saying is, instead of holding up the process of what's already is being presented in front of us, is that we just take time. It doesn't mean that it doesn't happen. It just means that today, let's focus on what's in front of us.
Looking out for public safety, public health, what I'm saying is that if we are pushing this aside or putting it out here, we could have a scenario where social consumption licensees are open and we have no means to do age identification through secret shopper because this is so self-limiting. So we are unable to execute that if we leave it alone, and we have cannabis cafes and events and hospitality, and we can't do these like the ABCC does, which we're trying to mirror a lot of this after the ABCC, and we can't do that. That's a real scenario because we are putting this aside, where I think we could tackle it over the next couple of days.
Acting Chair, I'm not in disagreement with you.
Okay.
So let's do it. But what
Okay.
I'm saying is, today in 30 minutes, that's not wise. If we're making any regulatory changes, if we're talking about a legal review, if we're talking about getting enforcement counsel, the chief of enforcement and investigations, 30 minutes is not sufficient.
But man, just for the record, this isn't the first time I brought this up. I brought this up many times.
It's not sufficient. Thank you.
Just offer as well, because the timeline came up. One of the things I'd like to cover as we move forward through this conversation, either today or tomorrow, is after the promulgation schedule, the implementation schedule for social consumption. So I do think that given the timeline here and the understanding that not having it available at the time that folks begin social consumption in the Commonwealth, I think that we can align those timelines and have that discussion as well. So I'll bring that timeline forward as well as we talk about what it looks like next steps for implementation beyond promulgation. I think that may close the gap there.
Okay.
Thank you, Executive.
Thank you. Thank you for both colleagues for talking about the issue. And again, Paula, this is the reality we all live in, is two commissioners can work on something. And in this case, I'm odd duck out, but appreciate the viewpoints. In secret shopper is something that we have definitely tried to navigate and find a way to bring to implementation. So I appreciate you bringing it up. And again, appreciate my colleagues for sharing their concerns about it as well. But it might be interesting to look at, when we have the implementation. And again, fully anticipating we need to do another round of of regulations. We've talked about that, talked about it, one around exclusivity, talked about it in other terms, are just generally kind of updating, and if I can characterize it as modernizing some of our other regulations that I want to say there's a second bite of the apple, but there's certainly another regulatory period kind of on the horizon. Something you want to flag? Go ahead.
Go ahead, I'm sorry.
Oh, go ahead.
to interrupt you. I've spoken with Deputy General Counsel, and he had flagged to, I don't know if this is the appropriate part to have this conversation, but around third-party transporter. Deputy General Counsel, do you think this is the appropriate time, or?
That first arises in 050.
Yeah.
So whenever, I think we are moving on. So I'll defer to the acting chair.
Yeah, I mean, unless it's, I think I know what you're talking about in 050. Question being around making a change in the definition, or are you in another section?
No, that's the section, but I do have a question on 005.
Okay.
We get to 005.
Acting Chair, I had a question.
Yeah.
And it's something that our executive director flagged around the promulgation and the timeline on regulations. I wondered if, because I made a reference to the next round, because I know we have exclusivity, that the period for delivery that does have to come up in April. When we discuss the rounds, promulgation, will that timeline be included, or is that something that we'll talk about a little bit later?
Yeah, thank you. Through the acting chair, I think, we've had discussions as well as certainly I&E legal commissioners have raised a number of things that they'd like to see in the next round. Regulatory modernization is actually the wording of one of the goals for 2025. And so I think we will want to discuss that probably at our August meeting, if not September meeting, of what we envision being in the next regulatory round. And certainly there are some deadlines specifically in there. You mentioned exclusivity being one, so it will be cross-referenced, yes.
Thank you.
Deputy GC, anything else? And I have a couple of things to bring up in the definition section. You're all set. Okay. The first one is page 5 under consumption area definition. Consumption area means a designated space approved by the commission within a social consumption establishment premises where consumers, it says, make, purchase, or consume. I'm wondering, because we define consumption is purchasing, consuming on site, whether we need to strike the or and put and.
This was slightly debated because of the conversation that we had beforehand. So I would say that this is up to the discretion of the board here on what they would like to see. We talked about before, and I'm gonna use an example that you folks might know. So if I go into a brewery, I go into one line and I can get a 4-pack to go. However, if I bought a beer there, I'd have to drink it there and I couldn't take it with me. So we need to distinguish that at our sites here. If someone goes into a consumption line and they buy something, do they have to consume it there? And we say that they can get an sealed exit bag to go. So they can get a doggy bag to take it home. They don't have to consume it necessarily, as it's marked up in this draft. But again, this is a policy consideration for you all. So, please.
Commissioner, go ahead.
I remember that conversation, Deputy General Counsel, and we talked about the scenario where someone buys a pre-roll, all of a sudden they can't stay. They haven't ignited it and they package it to go. So now we have to decide someone's intent. If, you know what I mean? So I think because then you can't how do you seal things up to go? has to be lit first, like if you take the or out?
And I guess where I'm looking at the definition, and you brought this up in one of the previous meetings about I haven't consumed anything, I gotta go because I got a call from home or whatever, how do I take my product with you? And obviously we have procedures for that. I guess what I'm looking at is this, not so much the point of sale or the transaction itself, or than what we want to define the consumption area as. That's kind of where I'm just leaning towards taking it back to how we're defining consumption is purchased and consumed on site. And that also kind of plays into our stricter regulations around you can't bring anything that's violent into the consumption. So. Go ahead. Yeah.
Thank you. So in thinking through this a bit with you all now, I think because it says may purchase and consume, that might be helpful in bridging this gap here.
Okay.
So if you say may purchase and consume, it's not requiring the consumption. So I think that might be.
You're saying because we have may in there, we can change or to and.
Yes.
Right? Okay.
Yes.
Okay.
Exactly.
I have a question because I think are we considering the point of sale to be the consumption area? I think that, so you're thinking that the point of sale is separate from the consumption area. So someone would be able to still purchase.
Yes, the distinction here though is if you have indoor smoking or outdoor smoking, you have to separate where you're able to sell versus consume. So we want to do that for a couple of different reasons. We don't want patrons to go into the retail and then get hit with secondhand smoke, or agents who are dispensing it in a similar way. So if the smoking is occurring indoors or outdoors, that is going to be separate from their consumption. The sales can be separate from consumption.
I see. And if someone were to enter the consumption area, I'm just thinking about this realistically. I'm thinking about this scenario live. You go into a consumption area with the intention of consuming, but we're saying there's a question on whether or not we allow them to change their mind and say, I just want to pack this up and go.
Yeah, the acting chair mentioned something that we talked about before of I get a call from home and all of a sudden I gotta go. Are we gonna make them consume it and spark the joint that they just bought? No, of course we wouldn't want to do that. Again, we are allowing them to take an exit bag home, so we are discouraging overconsumption in that way.
Right.
So again, this is the policy consideration for the board to try to balance here of how do we do it? It's obviously we're trying to regulate it similar to how alcohol is regulated, but obviously there's a distinction.
I'm in agreement with changing the or to and I agree with you, Attorney Baker, about may allowing that possibility. I feel like also by drafting the regulations to state that may purchase and consume, it promotes the consumption, but doesn't require it either. So I'm in agreement with that.
Yeah, and also, I mean, I think we would hear the argument from these licensees that we are disincentivizing additional sales. You know, by saying everything has to be consumed there, which leads me to another question, if I may, Acting Chair.
Sure.
We discussed the concept of deli style, and some of our licensees currently offer that, but we don't have a definition, do we, of deli style?
No, we don't. Although part of the amendments that I'm seeking to make here are going to be in 141.3, and they do kind of touch upon a greater allowance for social consumption establishments to we call it portion out servings, which again isn't quite deli style, but if it's allowed at retail and they're doing it, then they can do it here under social consumption.
Sorry.
So I'm wondering if we should include, that should be a definition, deli style.
Are you seeking to extend, are you seeking to extend that for all retailers?
What do you mean? I don't know.
So the way I understand it is that under the current regulations, retailers can already do deli style. So it doesn't seem as though an amendment is required for retail deli style. And because we are applying these provisions also to social consumption establishments, the same is true for here. I think the amendments that I'm seeking to make again in 141.3 is to give them greater allowances to do a micro serving or something like that. So to have a little bit more hands-on in the labeling and portioning of what they're giving to the consumer at sale.
Yeah, and the origins of my question, because like I wasn't in the working group, and so I was under the assumption this was going to be, deli style was going to play a major role in this license type. But then I think, correct me if I'm wrong, acting chair, you were envisioning opposite of that. Like if somebody wanted to do like a hashable, I'm going to just throw that out there as a term, as a product, you're envisioning they have to buy the whole tin, where they couldn't just buy one hashable, but now they can buy one hashable. Okay, which is.
I think that was our interest. I mean, you walk in, you kind of see a menu. You're right, you may not want to use your purchase limit of getting one tin and having one thing out of it, but you might be able to. So what I would suggest before you brought this up, and I think it's a critical element or business practice as to how these places could operate. Let's wait until we get to that section and look at it before we have to craft another definition. Does that work?
Yeah, I just wanted to kind of flag that concept. Thank you.
All right, so we will change or to and. Is there a consensus around that? The other definition, just quickly, is under principal place of business, which is on page 15. Just adding the term licensee of marijuana establishment. Okay with that?
Acting Chair,
Yes.
do you mind just elaborating more on the reason for?
Sure. It just, the way it reads now is principal place of business means the primary location where a marijuana establishment conducts its licensed operations and manages its activities. It just kind of looked like it was missing that definition and a further clear term after marijuana establishment. And just adding the licensee, at least for me, kind of clear that. Sure. Principal place of business means the primary location where a marijuana establishment licensee conducts its licensed operation and manages its activities.
Acting Chair, might want, I like your amendment. I might suggest that we go a little bit further and eliminate marijuana establishment and instead insert the phrase licensee. Because I wonder, I'm reading the definitions that they apply broadly. So we're not just talking about in the social consumption context, we're talking about all concepts here. So if we're saying marijuana establishment, that might be more limiting than just saying licensee. So my suggestion is to use licensee as opposed to marijuana establishment. And I welcome any opinions around that.
Yeah, if I may, yes, licensing will make it easier, more straightforward that is for not conflicting it with other areas of the reg that we want to go back in time and revise things. So licensing is fine, and then.
But we'll strike marijuana establishment just with the term licensee. Deputy Chief Seeker.
Yes, sir. So that would ultimately end up reading as principal place of business means the primary location where a licensee conducts its license operations and manages its activities.
Deputy GC, did you have any opinion on that?
I think it was fine the way it was drafted, but I'm not gonna die on the hill, so we can move on.
Well, but if you go back to page 10, I mean, we do give it a pretty thorough definition of licensee as well. They all won't be nitpicky little things as we go along here. All right, anything else under the definitions section? That's all I have. Also, oh, go ahead.
I guess I'm still confused. What's wrong with an ME? Like, all licensees MEs. But then MTC and separate things.
I looked at it as a marijuana establishment, but I was suggesting adding the word licensee after marijuana establishment. Commissioner Concepcion said you don't even really need marijuana establishment in front of it. And we already cover a definition for licensee back on page 10. Licensee being defined as means person or entity on the application and licensed by the commission to operate a marijuana establishment or ITL under statute 2016, chapter 334, et cetera, et cetera. So I mean, we can leave it in there, but it makes sense to, because licensee is defined someplace else, so get away.
Just for edification. So the hospitality licensee and the event organizer are still considered MEs? So there's nothing that would be outside of an ME
Besides an MTC.
besides, right?
I think the reason why I suggested just having licensee is because it covers more. When you think of a principal place of business, even for an individual, it's where you conduct your business. It's the place where all the records are held. It's the place where everything is originated. I was thinking back to the actual legal definition of principal place of business. And that's why instead of attaching it to the establishment, you put it to the licensee. So that was my line of thinking.
Oh, I see. That's helpful. So in other words, they go back to their office in the next town.
It's where they control the business. It's where they keep all the records. It's where they do all the engagements or business.
I think we created this context for the marijuana event organizer who may be doing their events someplace else, but their desk, office, records are held someplace else, more to fix location.
So now that's helpful, Commissioner Concepcion, but now I'm a little confused. Principal place of business means the primary location where a licensee conducts its licensed operations and manages activities. So to that point, if I have my office is in Worcester, but my activities are in Millbury, how am I conducting my licensed activities in my principal place of business?
Commissioner Roy, do you mind saying that one more time?
Sure. Principal place of business means the primary location where a licensee conducts its licensed operations and manages its activities.
And then
But aren't you managing the activity? So if I have an office right here, right in Union Station, but my activities, my events are in the next town over in Millbury. So I'm managing my activities in Millbury because that's the licensed activity is physically occurring and not my principal place of business, but my actual licensed activities are physically occurring in the next town.
I think
That's where I'm confused.
I can share them. I think it's important to just remember that when we're doing the definitions, it's for everything. It's not just for social consumption. This is for everything within our regulated industry.
Right.
So this also pertains to, we can use the same example for delivery licensees. Deliveries may not always occur where the delivery licensee is positioned,
Right.
but their main place of business might be in Boston, but they're outside of Boston. It's the same sort of theory.
So let me think of it a little bit different way, and I'll ask Director Copel a question, because when we look through applications, right, there's kind of the corporate address, but then there's also the business activity address. So, EC, go ahead.
Thanks, Acting Chair. And just one kind of additional point of context on this. I know we have had instances in the past where, and Commissioner Concepcion bringing up delivery licensees, I think is a perfect kind of example in here. So talking about couriers, for example, so a courier doesn't necessarily have like a physical office space that they're renting or something along those lines. They may be kind of operating the business out of their home and then utilizing their vehicle to actually perform those deliveries. So in prior instances, we have seen couriers getting host community agreements with different municipalities as well. So just utilizing the example, there could be a courier that is based in Worcester and they get an HCA, like their actual like home or where they're running their businesses in Worcester. They perform deliveries around the Worcester area, but they have they keep their records in another location. So they wanted to get an HCA with the other municipality. Based on this definition, they're conducting, the primary place where they are conducting their licensed activities would be out of their Worcester location. So we would expect the HCA to be in Worcester. So I think this definition also is clarifying that expectation that if your principal place of business or the location where you are actually managing or operating your business is in Worcester, that's where you need to get an HCA. So that I definitely view this definition as being helpful to define that expectation, particularly where it relates to delivery, courier licensees, but also just generally speaking, we do know that there are some licensees that have their main headquarters at a place that is different than their retail location, et cetera. So both of those locations are identified on the application. They're in Mass CIP, but we would be able to identify that, okay, your retail operations are conducted here, your principal place of business where your office is, et cetera, is in a different location. So that helps to kind of create that specificity when we're talking about those.
I guess I got hung up on the word activities is where I got hung up. Is there a better word than activities? Because activities, you're actively participating in something. I just don't know if there's a better word than activities. It's business operations, manages its license and business operations. I think it's a little bit of a mislabeling because you're really not managing the activity. Can you combine it? Conducts and manages its license operations.
You're suggesting combining the two, saying conducts and manages its licensed operation.
Full stop.
Stop after them.
Unless there's a need that I'm not aware of.
Any thoughts?
Can you just repeat it one more time, Commissioner?
Sure. Principal place of business means the primary location where a licensee conducts and manages its licensed operations. Us.
Can I?
Yeah,
Can we take our conduct?
yeah, I was gonna say conducts doesn't make sense.
Yeah, based on the conversation, it looks like conducts comes out and then. now it's
Manages.
Principal host of business means the primary official, where licensee, manages,
Licenses.
is licensed operations.
I think that makes better sense.
Yeah. Sounds like that would cover everything
I-
that was just discussed here. So yeah, principal place of business means the primary location where licensee manages its licensed operations.
That's more appropriate.
Dropped into the chat, so we have it. Thank you. Okay. Got that change? All right. Happily, that's all I have under definitions, so we can move along. Deputy GC, why don't we go to 500,005, which I think it's on page, there's some changes on page 22 under this section.
Yeah, 21 and 22
Fees.
is where the fees sections are at. And throughout the discussion, as I've said before, if we're giving a page number, we're going to give the marked red line version in the bottom right-hand corner.
Page 22.
24, no? What page do you have, Mike?
22.
22. Ah, yes, okay.
So again, these are the application fees as well as annual license fee for the supplemental, the hospitality, marijuana event organizer. Again, just pointing out 1,500 each for supplemental and hospitality, $1,000 for a marijuana event organizer. And the license fees all aligned at 5,000. And below, you see a marijuana event organizer site review fee of $250. Any questions for that? Commissioner Wright, go ahead.
Oh, thank you, Acting Chair. On the marijuana event organizer site review fee at $250, is that a one-time prior to the event? Like, can you explain the vision of that?
So I'm happy that this was brought up. I think the acting chair wanted to discuss this specific provision of whether it's required in light of the fact that we are municipally permitting now, as opposed to bringing the permitting process under the commission, in addition to the municipal permitting. So obviously, it's at the board's discretion if the $250 site review fee is still necessary. But we did change the procedure here. So the way it was envisioned upon the initial draft was that they would, our enforcement staff would go review go to the location of the temporary consumption event, and that would generate the fee. So that was the initial thinking of it.
Now, as we're thinking about it, where more documentation is submitted to us. Again, we all keep in mind that any fee that we generate, we don't get to keep to cover our expenses. It all goes to the marijuana regulation fund. So, we can have a question around, I think as we get into the other sections, we'll talk more about the marijuana event organizer license and some of the changes that we made there. I guess a question right now at this point would be, do we feel we should be charging a fee? Kevin?
So what's proposed now is not what was originally envisioned, so it's more local controlled. So are we doing a site review? Like, we're not doing it as originally envisioned. So I don't know if it's appropriate to charge for something that we're not. It's more local control. I just don't know.
The way that the conversation arose at public meeting last time, this is where the commissioners landed, that this would be included. So I didn't want to remove it because we could still require staff to do that.
Right.
But again, this is a policy position for you all. Do you want staff to do that? And if so, do you want them to charge the fee?
Let me suggest something. We can come back to this after we get through the changes that we've made in the marijuana event organizer license and then decide for ourselves if we want to keep the fee or not. Again, we don't keep the fee. When I say we keep the fee,
Loosely
it,
defined.
it does go, and again, it's consistent with applications of license renewals that they all go to the marijuana regulation. So let's set that aside until we go through changes that we made around the marijuana event organizer. Next section I have is 500.029. This is registration and conduct of laboratory agents. On page 24, again, this was based off our previous discussion in a public meeting, but under number 6, trying to align it with other MEs. 6 now read, a registration card shall be valid for 1 year from the date of issue and may be renewed thereafter or on a triennial basis on a determination by the commission that the applicant for renewal continues to be suitable for registration. So that's consistent with our ME agent licensing requirements or allowances, that they also have the opportunity to be renewed on a triennial basis. Triennial, is it IAL, not UAL? And make that spelling correction. Any questions on this section? If you're okay with that, we'll move on to 030, which is registration of marijuana establishment agents. There is some amended language under this section, but the important one for me is the change we made to number 8. The new language now reads, a marijuana establishment may be issued a single agent registration card covering all licenses held by the same entity having direct or indirect control. So the language that we would be striking, this gets back to our goal of having one badge for agent, regardless of the number of licenses held by the same entity having direct or indirect control. Any thoughts? Go ahead, Commissioner.
Not on 8, but on 3, there was amended language.
I think we went through that one before, but
The quarry.
Yep.
Okay, my question is for Director Coble. On page 25, number 3. The blue language in blue provided, however, that a query shall not be required when one was already completed for an employee transferring to or working within and between related licensees sharing common ownership.
Oh, what's the question?
So so background check is good for 1 year.
Yep.
Okay, and so if someone works, say I own 3 of dispensaries, so that I understand the badging, they'd have 3, we're trying to get rid of that, so they'd have 1. You don't need 3 quarries. You have 1 quarry for 1 individual, right?
So what's been happening is there's a quarry waiver process. That's been, so if, for example, establishment X has 3 different locations. And I got a quarry for my first location for my establishment. For the other 2, what's been happening is we've been getting quarry waiver forms saying, please waive out of this requirement because I've already done the quarry for the first location. But that is something that we're also discussing with legal because our regulations seem to have changed since from when they first came out. So
Yeah.
just trying to get some clarity
Okay.
from them.
So this language eliminates the need for the waiver?
It appears so, yeah. In my opinion, that's what it appears to.
That's what we're trying to accomplish here. So if I own 3,
Mhm.
then I only have to do, and I have an employee who works at all 3, then only 1 quarry needs to be
Correct.
done, and they can work at all 3.
That's how I'm interpreting.
Okay, I just want to make sure I understand this. Okay, now, do you need language in there about it's good for a year? Or you feel because it's stated elsewhere, it's okay
I think it would be helpful to have language about 1 year.
in this section?
Yes, I think, that anytime we can be prescriptive, obviously not over prescriptive, but in this instance, it would be helpful to have that language.
Okay,
Deputy GC White and stepped out. Commissioner, I have questions about number 3 under 030 on page 25.
so my question was, what was the current policy? And Director Colville explained it, that if I own 3 and someone works at all 3, technically 3 quarries would be done, but people are submitting waivers so that they don't have to triplicate their efforts. And so that would eliminate the need for the waiver. But my question was around the how long it's good for, and that is good for 1 year. And do we need to incorporate that in light of this new provision?
Yeah, I think that makes sense. Obviously, I hope that this amendment is helpful for licensees to not have to
Definitely.
overly spend on this quarry.
Look at quarries, right?
Do we have suggested language on how we could incorporate that into this sentence, or do you want to wordsmith it now?
1 year piece,
Yeah.
Mhm.
Director, go ahead.
It's not to your question, but one thing for clarification for the board. How are we addressing situations where there are different holding companies? So it might be the same ownership structure, but different holding companies. And I know DOI wanted to.
Yeah, so just to give a little bit of context, we certainly have various companies that ultimately have the ultimate parent company is the same, but there's various different levels in between once it gets to the licensee, and the licensees have different names or held by different legal entities. Is the intent of this for, if they're ultimately owned by the same entity, that they can just have 1 agent, 1 registration badge, excuse me, or is it the ownership structure needs to be mirrored?
Are you talking about, are you on 3 or are you on 8?
This would be for subsection H, that is a single registration card covering all licenses held by the same entity, having direct or indirect control, because typically there's various entities holding direct or indirect control.
Go ahead, Commissioner.
So my question back, that's a really good question. When we do stipulated agreements and we do enforcement actions, who is assessed ultimately the fine? Is it the parent company or is it the grandparent company, the holding company? Like who ultimately holds the bag on the fines and the enforcement actions on that?
Yeah, I can speak to that one, Commissioner Wright. So in a stipulated agreement situation like that, we are attaching a fine to the specific license. So that's the license, not necessarily a holding company or something along those lines.
Okay, so if they're the ones ultimately responsible, the licensee, should that, I'm asking the question back, should this mirror that for consistency?
That would really. I think it just gets into, if this is meant to be a relief of some sort, when you have agents working for MSOs, for example, that may hold their licenses in different entities, it may not grant the relief that the board intends. If the license is held by different entities until it gets to the rate or grandparent structure.
Go ahead, Director.
I also have an additional question at how this would impact the triennial renewals. So, for those, we would only be seeing them every 3 years, the actual application for the renewal agents. So I don't know, for the board's consideration, if we would want to put language in there that, despite the renewal having to be every 3 years, you still attest to doing a background check yearly or something along those lines.
Trying to parse out, is that question applicable to section 3 more than?
I think so. Yeah, I think it would work for question 3.
Okay. So we're juggling some amended language we need to add under 3 and also looking at 8. But we can clearly define that if I'm working for an entity that has up to 9 licenses, I only need that 1 registration card. So how are what's the best way for us to identify that entity? Is it licensee? Is it licensee held by the same entity having direct or indirect control? Trying to solve the language on 8, and then we'll go back to some clarification on 3. Commissioner?
I guess my question for licensing is now you got to do a deep dive into, so for every agent registration now, like, is that realistic? You're gonna have to do a deep dive in every single one of these now to figure out who the parent.
So you typically currently what the process is that, so let's say establishment X has 3 licenses, all under the entity name X. They would provide us with the license numbers of the other places the agent works at and what the query waiver would be for. I do think it would get tricky if the same ownership structure had, entity X, entity Y, entity Z, because then we would have, to your point, have to do some deep dive to ensure that what they are representing is correct. Which we have seen. We've seen not in an agent instance, but we have seen definitely, the same entity structure, like to Catherine's point, owning different entities for, for tax reasons, whatever reasons may be. So it would cause some additional work required for that.
Okay, and now we have ESOPs, which are owned by the employees. So lacking that, and you're gonna see there's about 4 ESOPs now, and I think you're gonna see more.
And historically, the ESOPs have had to go through the change of ownership process to be added as an entity.
Yeah, right.
If I may, Commissioner, all right, so this will also require that we amend our forms, to allow them to be able to disclose, all affiliated licenses as well. That's something to think about. But then, so that we have a full understanding, what's really the intent here regarding this reg? What's the intention?
Talking about the changes in 3 or the changes in,
Yeah, changes in 3.
We should stick to one provision and talk about.
yeah, let's try to solve concerns around 3 and then we can move on to. Okay.
So if I may. So my concern on 3 was to make sure licensing had what it needed, and that was to be consistent with it has to be a current quarry good for 1 year. That was my initial concern around that.
Okay.
We're still waiting for a response to Chief Kamal's question. Chief Jones, I apologize. It's just that that was a question I had too, so I wanted to hear what the response was.
She has the intent, and I just said my intent. Oh,
No, the intent of the drafted language.
oh,
That's what your question was.
oh.
I mean, again, what I think I heard from Director Koval and from Deputy GC is, does the language in 3 address the issue of being bombarded by quarry waivers because somebody's already gotten one quarry from one agent registration that they might have? They're seeking additional quarry waivers when they go to work for another license held by the same entity. So we're trying to clear up that process so you don't get bombarded by quarry waivers. The question is, does that language speak to it? And I think to Commissioner Roy's point, does it address the annual requirement of that? Commissioner,
I think I want to understand sort of the prominence of the issue. Like, are you being inundated with a lot of waivers, or is this an issue that we need to tackle? What is the reality of it?
There are a fair amount of waivers. Yes, I don't have a number. I could get a number, but we do have a fair number of waivers.
Horseman Council.
Thank you. I just wanted to add in here as well that when we're discussing this and using the term waiver, this isn't a waiver in the traditional sense. This is utilizing a different form that the licensing team has used for a couple of years, and it just identifies this. This is really kind of noting that a background check has been performed within, I believe it's the last year, and it is indicated or noted in that form. So it's not a waiver that you might be thinking of per our regulations or per 850 specifically. So just wanted to make that clarification. So we're not going through the same 4-prong analysis where we would go through all of that. This is kind of noted or taken care of through the process.
Get a waiver. Oh yes, we already have your quarries, so we can approve the waiver. And now we're trying to lessen the paperwork flow, both for our licensees and for our licensing team, is to, okay, we have Commissioner Concepcion's quarry. It's good. She goes to work for some, an additional licensee. She doesn't need to do a new quarry because we have it. So it's getting around them having to file a waiver saying, we feel we need to submit it because you already have one done.
Correct.
Yeah. Go ahead, Commissioner.
I feel this is timely in light of social consumption because this license type is open to micro businesses, to delivery operators, to our SCPA retailers who chances are some of their existing employees will want to work in this separate license type. And why are we gonna make them do another quarry again? It doesn't make sense. So I think honestly, if we can button this up, it makes your life easier, it makes licensing easier, you know, it just relieves of the unnecessary burden for the commission and the licensees.
Right.
As long as it's current.
Correct.
Go back to your original suggestion of how do we fill in that quarry, as long as it's not over a year old. That's what you originally brought up and you want to make a reference to.
Right. It could be pursuant to 500.03035. Could just cite that there. Does that make sense? In general? Oh, that's the registration card number, right? Let's try that.
So is it adding a term in front of Corey to either say current or valid? Instead of valid, Corey, that be an appropriate reference?
You repeat the suggestion, Mr. Chair. Sorry, you repeat your suggestion.
In the new language under 3, provided, however, that a valid quarry or a current quarry should not be required when one was already completed for an employee transferring to or working within and between related licensees sharing common ownership.
All right, my understanding of where we are right now is that we're looking to try to account for the 1-year requirement within this provision.
Yep.
So is there anywhere that we can amend in this sentence or create an additional sentence here in 3 to speak to that?
Instead of valid or current, when you say that a quarry shall not be required when one was already completed within the past 365 days.
I can try, I like that suggestion. When you say valid or current, it's just subject to interpretation.
Provided, however, that a quarry shall not be required when one was already completed within the previous 365 days. For an employee transferring to or working within between related licensees sharing common ownership. Any questions? Director Caldwell, go ahead.
So just to clarify, for my own understanding, so again, in what DOI and I were discussing, so if it's a common ownership, but the entities are structured separately, meaning, they have, establishment X, establishment Y, establishment Z, all under the same ownership, would they also benefit from this regulatory change? Or is the intent to only apply it to those instances where establishment X has 3 different license types under establishment X. Also common ownership, obviously.
Sorry, Chair.
Go ahead.
My interpretation of this would be that it needs to be the exact same, mirrored throughout, and if there's any variance in ownership, then they would not be able to benefit from the relief this provision is granting.
So I guess my question is, it's difficult without calling out names. Like right now we have licenses that literally, it's the same ownership structure, but they'll all be under, let's say, name marijuana, so they'll have a cultivator, a product manufacturer, a retailer, and they're all named marijuana. But then there'll be other ownership types of structures where they'll have, let's say, their retailer will be called Marijuana Boston. Their product manufacturer will be called Marijuana Flowers. So the entity itself is different, but the ownership is the same.
But if I'm reading 3 correctly, and we do want to put that time span in there, the query was done within the previous 365 days. So under 3, working within and between related licensees sharing common ownership. So going back to your example, marijuana owns 3 product, 3 cultivation, 3 retail. That's their limit. They want to own more. They would be changing up their ownership structure, right? So it wouldn't be common ownership.
I guess, so if marijuana was adding more licenses, they should be having the same ownership structure. So, if Commissioner Roy, Acting Chair, Commissioner Constantino, if you guys own the 3 marijuana licenses and you're adding more, you should have the same owners.
Right.
Yeah. So that's the instance where we get query waivers now, so if it's just marijuana has 10 different licenses, we apply it to all. But for example, if the 3 of you own 3 different licenses under 3 different entity names, the query waiver would not apply currently. So I'm fine either way. I'm just ensuring that, whatever the board wants to do, is clear.
Interest, I just want to make sure my understanding is correct. So you're saying it's a different entity, but same ownership.
Correct.
In that instance. And that, I see.
And I think it's done for tax reasons, I obviously it's speculative. I don't know what the reasons necessarily are, but there are certain entities who structure their businesses that way, rather than putting it under one name and having all the licenses under one name. They like to split it up as having it having it looking like different businesses.
Does the term is currently drafted under 3 related licensees speak to that? So common ownership, by the way, you're spilling secrets as to what our next venture is going to be, but the 3 of us have common ownership of 9 licenses. Regardless of what you call those 9 licenses, they're all related licensees, all shared by the common ownership.
Yeah, it could definitely speak to that. I just wanted to clarify for ourselves what the board's intent was with the way it's drafted. If you guys, are you okay with taking that approach?
Because the way that I was hearing it originally and the way that I still envision it is, now I know Acting Chair was referencing provision 7, so I don't want to conflate the 2, but it should be aligned with how we allow agent registration cards. So if we would not allow an agent to carry those cards into the other entity, then I don't think that the query provisions should do the same. You know what I mean?
Right. So
It may require us, because we don't have similar language under 8, that we need to align 3 and 8 perhaps a little bit better.
Oh my goodness, I meant to reference 8 and not 7.
That's all right.
I meant 8.
yeah, I knew what you were referring to as well.
My radar screen.
But yeah, that's a great point, because to your point, it's in that vein, even if there was common ownership, unless the board decides to change this definition, even if there was common ownership, an agent wouldn't be able to go from marijuana, Boston's a marijuana flower to marijuana X, even though it's common ownership.
And I'll add another comment to that. I think because another reason, aside from tax
Mhm.
purposes, is also liability purposes.
Mhm,
And that's why
mhm.
people construct things
Yeah.
a certain way. And I think this should also align with that, because if we're talking about liability and that falls
Right.
to Corey and why
Right.
people do the background checks, it should absolutely be maintained within that entity and not if they're
Across.
exactly.
So is there the opportunity to take some of the language from 3 and incorporate it into 8 so that the language is consistent? Yep. Go ahead.
Thank you. So we say licensees sharing common ownership under 3, and then under 8, we say, the same entity having direct or indirect control. Obviously, we should try to marry them as best practice. And so I'm asking enforcement staff, do you have a preference on how we would say it? Common ownership and control does arise a few times in the regs, but the defined term under 8 is, I think, probably preferable. But I didn't know if any of you had a suggestion.
Director, go ahead.
Can I just ask a clarifying question? When we say sharing common ownership, do we mean identical, or can they share one entity? And I think when we're on break, we can give kind of specific examples. But the ownership structures vary, but there's a lot of licenses that, yes, for tax purposes or whatever, they're held under separate entities. But there may also be that your cultivation license has some different individuals on it than your other held licenses, even though the majority owner is still the same.
And I think that's why my recommendation would be to go with the language under 8, where it's the same entity having direct or indirect control, which again, isn't quite a defined term, but throughout the regs, it is drafted in such a way that it brings both classes into one here. So
I'm in agreement. I feel like that it also solves what we're trying to get to as well. Director Koval, like you usually bring up things. I'm noticing this that make my wheels start turning. So I'm in agreement with using the term entity as opposed to shared ownership, common ownership.
Go ahead, Commissioner Wood.
Deputy General Counsel, in 8, do we need to broaden that a little and put the same individual parenthesis S and or entity? Because when we do changes of ownership, we add and remove individuals, we add and remove entities. So I don't know if we have to go a little more granular there.
then we could say individuals or entities.
With the parenthesis S, like individual with a parenthesis S at the end of individual, because persons, as opposed to individual persons.
So persons or entities having direct or indirect control.
Should we change the change of ownership forms then? Because exact to that, because that's where I get confused.
And not to throw a wrench, but could we possibly talk about some break just to give examples before anything's, just so you have as much information as possible?
Sure. Why don't it's 12:45. Why don't we take a break? We'll come back at 1:15.
I'm wonderful. You want to be mine?
All right, reconvening, apologies for somewhat extended break as we had conversations with staff. So returning to page 25, again, this is around agent registration. Subsection 3 is around query requirement. And subsection 8 around making sure that a marijuana agent only has one single agent registration card covering all licenses held by the same entity having direct or indirect control. After much discussion, a couple of suggestions, one being to simplify some of the language around the query check. There's a suggestion about referencing obviously other regulations which guide that a query is valid for 1 year. Turn to Deputy GC. Do we want to incorporate a citation there as opposed to adding any additional language? Could that work?
I think we could just reference CMR, Commissioner Roy indicated, and I would just say at the tail end of the sentence, you could say in accordance with that regulation.
I'd be okay with that. Obviously, the next question we're still wrestling with is the language around licensees sharing common ownership. And then obviously down under 8, we have licensees held by the same entity having direct or indirect control. Just trying to, one, align the language so it reads consistently, perhaps in both places. But you know, Deputy JC, I didn't know if you had any additional thoughts. Obviously, thank Director of Licensing and Director of Investigations for sharing some thoughts about some of the complicated structures that we know our licensees operate under.
I think for the purposes of subsection 3, we could pull the language used under 8 to include, instead of common ownership, we could say persons or entities with direct or indirect control for 3.
So where under 3 would you offer that amended language? And drop it in the chat also, you can read it.
Yeah, before writing it out, I would say between related licensees who share persons or entities with direct and indirect control in accordance with 803, blah, blah, blah.
Okay. So how would you amend the language under 8? Excuse me.
I actually haven't gotten there yet. I'm still trying to draft this one.
Yep.
But I'm willing to take your first stab at it, Mr. Acting Chair. If you want to offer.
Okay. I mean, under 8, could we read a marijuana establishment agent may be issued a single agent registration card covering all licenses held by persons or entities with direct or indirect control? With the same person or entities with direct or indirect control? Sorry, Commissioner Wright. Go ahead.
Establishment a single agent registration card covering any licenses, all licenses held by, how do we say it?
Go ahead, Director.
Thank you, Mr. Chairman. So there's various ways this could be written, and it has to do with what the board envisions in terms of intent. Essentially, is it meant so that it's the same entities having direct or indirect control, meaning that the structure would need to be mirrored in order to do that? Or if it's, if there's any entities or persons having direct or indirect control, meaning that if there's any entities within the ownership structure where they share ownership, they would be allowed to do this. So one's more strict, one's looser.
All right, help me understand which one do you think is a looser?
Sure, so if we have the same, this would need to say held by the same entities having direct or indirect control. That would be that the structure needs to essentially be the same. So for license 1, 2, 3, 4, 4, 5, 6, the structure doesn't vary at all as you go up the chain. If there were to be language that states that they can share any entities having direct or indirect control, those would catch some of those entities that have different holding structures, but have the same ultimate parent company, we'll call them.
I mean, for me, by conversation on this, I'm okay again, because this is only draft language. I'm sure we'll get lots of comments about this as it goes through the process, but keeping it limited, I think, to your first point about the same entity having direct or indirect control, which I know is probably the more stricter language, but we could start with that and see how it gets reviewed and the comments are shared by the industry when we go through the promulgation process.
Thank you, Chair. I'm in agreement with your suggestion. I think what I wanted to throw out there is having the language in 3, so that tail end language that you just amended, Attorney Baker, that it mirrored the language that we're having in 8. So incorporating that same term, same, just making sure it's captured there as well.
So Director Pinkowski, the language in the chat is somewhat the similar language we would use down below.
Sure. It's just the key phrase though, same, being the
Right.
the phrase that we would want. So in the draft language that you're reading, just imagine with the term same.
Yes, so this draft language says who share persons or entities with direct or indirect control. And it will be persons or entities having direct or indirect control. But this just says between related licensees who share. So this would be looser if we who share the same persons or entities with direct persons or entities having direct or indirect control.
So if we wanted, again, because this is only a draft version for us to put out, if we took out related and just say between licensees, take out the word related, just say licensees who share the same person or entities having direct and indirect control. Oh, I'm sorry. Commissioner Rico.
I have a question, might not have the answer to, so, sorry, Olivia. Is there any of your cultivators that you're aware of that are owned by different persons or entity who may own a different, in other words, they need temporary help. And if we limit it on the stricter version, I'm thinking about their cultivators who need temporary help that I don't know if any of them are owned by entities that have other entities.
Common ownership. I
Yeah.
can definitely ask my team to look into that because I don't know that.
That would
I see
limit
what you're.
them, the stricter interpretation, where the looser interpretation,
Mhm.
those people could work there for that limited crop time.
Yeah, I see the point, definitely.
I mean, I appreciate I was more focused on what Director Binkowski has put in as the stricter language. I'd be a little reluctant at this point to adopt the looser language without giving it a little more thought. I'm open to that language, and then again, would certainly want to see what kind of feedback we get on this, but I'm okay with, I'd prefer to stay with what we're saying is the strict language. And then again, as we go through the promulgation process, kind of see what feedback we get. Just for the purposes of discussion, and then taking some of the same language at the end of 3 and putting it into 8. Commissioner Morricone.
I guess I'd like to learn more about your thinking on that, because who does that benefit at the end of the day? So the looser interpretation benefits employees, they have more options for bigger employee pool. The looser interpretation benefits the license, the employees and the licensee, because there's more options on either end. Unless it's completely burdensome to the commission, I'm not sure who. I think it's more beneficial. More people would benefit in the industry with the looser interpretation, but unless it's something I'm not seeing, or maybe there's something I don't realize internally.
Acting Chair,
Go ahead, Commissioner.
I have a question for Directors Binkowski and Director Cobal. bear with me because I have a thought and I want to try to get this out to, I'm thinking through the looser language. And I'm wondering if there was an issue that arose at one of the entities. We talked a little bit about liability. And who carries that? We talked about NODs and how that can kind of go across if it's all the same direct and indirect owners. But then if you have variations, it wouldn't be, I don't think we could issue an NOD against another entity when there are different owners involved, because they're not all affiliated with the owner that. I hope you understand where I'm going with this, Director Bukowski. I can try to clarify it more, but I'm kind of going through a process right now.
Sure. So in terms of the NOD process, wherever the deficiency is identified or discovered, that applicable licensee would receive an NOD. So even if they have different ownership structures, if there was a deficiency identified at a different licensee, if they were in violation, they would be cited for it regardless of the.
So it wouldn't impact either way, the strict or the loose language. The NOD would only relate, but then that doesn't really make sense either because the agent will be working across entities.
Which type of violation are you thinking of for like an NOD for an agent?
I'm thinking about a suitability violation.
So suitability, we would have a suitability referral process. So that would be if they were deemed unsuitable or were being recommended to be deemed unsuitable, it would be whichever licensees they worked at.
But it's a common agent. So I guess that's where I'm getting hung up because the agent now works across entities.
Right, so in terms of the suitability itself would impact the agent. And, you know, if there was a suitability finding, a negative suitability finding, presumably they would no longer be able to work at any of those licensees. But and please feel free to jump in, EC. It wouldn't affect all the licenses in terms of, there would be no, I guess, retribution but jump in terms of, would it affect all the licenses that the agent is working at with the suitability issue?
Yeah, I can jump in and speak to this, and Commissioner Concepcion, you might need to repeat the question just to, if I'm going off track of what is going on, that might be helpful for me actually just answering it.
So we currently require to be informed if there's a suitability issue arises.
Correct.
But we have an issue where, let's say one entity tells us, so we know, but the other entities that have direct or indirect control over entities where this agent works failed to provide that information. I think I'm answering my own question as I'm fleshing through this, actually. I think we have a resolution already. Because it still could happen because they're still working for those entities. I've answered.
Yes.
Thank you, Attorney Gooden.
Happy being on the journey with you.
So Commissioner, where does that kind of land you in terms of?
It's a non-issue. I thought it was an issue, so it wouldn't be impacted either way, which doesn't bring me any closer to a strict or a looser. I was hoping that it would tilt it. Yeah.
Again, my preference would be to move ahead with, at least in terms of offering in the draft regs, the stricter version and holding aside maybe the looser version, just in case we, depending on the type of feedback that we get, but just like for some thoughts or consensus from my colleagues, if you would prefer.
Acting Chair.
Commissioner.
I appreciate that. I think what you're saying, the direction I'm in agreement with. My question is for our Deputy GC. Are we keeping a repository of these like where we have provisions like this where we're saying we could go the other way? Is there any way to kind of track that? I know that might be a tall order, but
No, but I'm happy to keep it in my notes.
okay.
Commissioner Roy. Go ahead.
We didn't get anything on the outdoor cultivators, right? I know I asked them.
Still waiting. It's gonna take a little bit time to gather that information. And that's kind of what I was, when we were discussing, I was trying to explain the difference for the licensing team in the strict review versus the less strict review. Is in a strict review, you would have to do this due diligence of checking the ownership and cross-checking with all the other licenses to find, for your question, for example, in this instance, if there's anybody else with the same ownership. So I will let you know, somebody on the team is on it.
Big ass.
No worries. I'll put it in the chat as soon as we get it.
And I appreciate that point. And when we did talk about agent registrations at a previous public meeting, I think I had raised the idea, you and I have visited outdoor cultivators and know that that's a challenge. And I think it's still one that needs to be addressed. But we've also talked about some other agent registration issues kind of going forward with respect to RET and a few other things, but again, we'll see what information that comes back. But like I said, I'm happy to move with the stricter language. As a regulator, you need to say the stricter language, but one that's obviously more easily understandable for our licensees and also for our team in terms of managing that responsibility. I just see looser being a lot of work on licensing it and to kind of track down who's doing what, who's connected to who. Go ahead, Director. And then
Yeah, in that vein, also, it's in line with what we're currently doing, in terms like we're looking at just on the entity level for that to be the same. We don't look at the parent, grandparent, umbrella company. So it would be consistent with what we have been doing.
Enforcement Council.
Thank you, Acting Chair. And just one suggestion in terms of the language here, and I'll happy to defer to or work with Deputy General Counsel in terms of like the specific placement as well. But it may be beneficial here, Commissioner Concepcion, to your point, and also in conferring with CIE, to add a cross-reference here to just say that provided, however, agents or registered agents must notify the commission of any changes to their suitability within the time period. And what I mean by cross-reference is cross-referencing the actual sections related to the appropriate suitability sections. Just to emphasize that while we are not getting queried necessarily every year or on the same pace, that if there are any changes, that is still an obligation. So just making sure, emphasizing that point rather.
Okay. All right. So obviously we'll hear what Director Cole hears back from our team with respect to outdoor cultivators and any cross ownership of outdoor cultivator licenses. How can we, just to move along here, if we look at number 8, and again, a marijuana establishment agent may be issued a single agent registration card covering all licenses held by the same person or entities having direct or indirect control. Does that language make sense? Trying to mirror it and align it with as much as we can with 3.
Chair, do you mind repeating that again?
Sure. Reading 8 is a marijuana establishment agent may be issued a single agent registration card covering all licenses held by the same persons or entities having direct or indirect control. It'd be the only difference really than the language above. Obviously, it would align with the stricter language we're thinking about for 3. It would just, the only difference between that with the looser language, it would be share persons or entities having direct or indirect control. Okay. All right. We'll move along knowing that we may have to come back and revisit 3. All right. Jumping down to this. I had some notes, page 30 and 31. I think this is under 050. You see some language under 30, and this is more just a highlight. I don't think any of this language has changed. Highlighting a eligibility, again, putting in the eligibility that a marijuana cultivator may pursue a supplemental on-site consumption license. Craft marijuana cooperative may operate a supplemental on-site consumption license. A eligible marijuana product manufacturer may operate a supplemental on-site consumption license. And marijuana micro business at the top of 32. And third-party transporters, we had that over on page 35. Commissioner Roy, I think that was your suggestion from our previous meetings. We addressed retailer, and then Deputy JC, help me out. We also said, oh, page 38, a eligible delivery operator may also operate a supplemental on-site consumption license within its existing marijuana establishment premises. So that's just aligning all of our license types. Obviously, delivery doesn't necessarily have brick and mortar. But any questions on those? And then we'll come back in the deeper dive on the 05. Sorry, go ahead.
I had a question on the third-party transporter. I just wanted to understand it a little bit more on how it operates in reality. Sure. Deputy General Counsel.
Well, I had indicated to the acting chair that I wanted to raise this issue because at our last public meeting, Commissioner Roy advocated for including third-party transporters in the class of licenses that could obtain a supplemental on-site consumption license. So because of that, that begs the question of what to do with the conflicting language in 050 here under third-party transporters. So wanted to bring it back to the board on how do you want to go about, if there is consensus to implement third-party transporter, how do you want to go about implementing that conflicting language into this draft? Because right now they're not allowed to hold another license.
I think my question, Acting Chair, if I may,
Mm-hmm.
I just wanted to understand. Sometimes my interpretation is not what the intention is. So I wanted to understand a third-party transporter would use this how? Like, how would they operate a social consumption space?
So my understanding of third-party transporter, similar to a delivery operator, warehouses products. So they're very similar in that regard. So I don't see a reason not to include them unless one can.
I just want to understand it.
Yeah. So in speaking with third-party transporters, many of them similar to a delivery operator, only they transport larger amounts in their vehicles. But they have warehouse space and like micro businesses, it's self-limiting. The third-party transporter is a little bit self-limiting. So this is an opportunity to loosen what they're able to do in the regulated market. It's a former staff member once said to me that we should just have one category, the marijuana transporter, and not break it down into the third-party transporter and the existing licensee transporter. And that would be a fix. I think, Mike, you're alluding to that. We can do a simple fix, getting rid of the line saying they can only hold one license, or we can do a holistic fix of the entire license type.
Go ahead.
Thank you. Yes, that's essentially why I didn't feel comfortable making an amendment here for this, because I didn't know which direction the board wanted to go into. But I think that Commissioner Roy spelled it out pretty well.
That's helpful. So the idea is utilizing the warehouse, not the vehicle. The reason why I asked that, because when I read this, and the same can probably be said about a delivery courier, I envisioned like an ice cream truck, which was a conversation that was had prior to us joining by the previous iteration of the Cannabis Control Commission. And I said, we're going into a territory that I don't think was intended. So I want to make sure we're using language here that is really clear about what we're permitting and what we're not.
Yeah, I think the draft language says, well, first of all, it does help clarify, right, that the third-party transporter cannot hold another MU license. A third-party transporter may operate a supplemental on-site consumption license within its existing marijuana establishment premises. So I don't know, the premises gets away from the ice cream truck analogy, but
It does. It does. Thank you. And thank you, Commissioner Roy.
Oh, thank you, Brett.
one of the only things, again, I would note page 35, I believe, and Deputy GC will correct me if I'm wrong. Page 33 up under G, it says the commission shall not approve a licensee for participation in a temporary consumption event if the proposed participant has an active enforcement action, summary suspension order, or limitation of sales order. I think that's relatively new language, if I'm not mistaken. Essentially saying an event organizer puts together an event, has a number of licensees participating. We would not approve a licensee for participating if they had some of these outstanding issues. Someone saying we won't reward good behavior. Deputy GC, go ahead.
I don't want to confuse us. You're bringing up the marijuana event organizer license. We were just discussing supplemental.
Oh, I'm sorry. Yeah.
But just want to.
No, I'm just going through my notes under.
Yeah.
Just going through my notes under 050, right?
And yes, that is new language. To just go off of your comment, Mr. Acting Chair. That's important because we allow for the marijuana event organizer to have the option of warehousing or not. And if they choose to not warehouse, then they have no physical space to store products. And so if that's the case, then they're going to want to have a marijuana establishment sell at retail during a temporary consumption event. So we want to make sure that they're in good standing if they're going to partner with our MEO licensees.
And that fits into temporary marijuana event organizer. Obviously, we'll get into a little more discussion about roles and responsibilities between municipalities and the CCC. But from our perspective, one of the things that we're going to do is make sure that any licensees participating, first of all, we want to make sure that companies participating in these kind of sanctioned events are licensees, and in this case, give us the opportunity to make sure that there are licensees in good standing with the commission. I don't know if my colleagues had any other thoughts under this section, under 050.
Mr. Acting Chair.
Go ahead.
Thank you. I just wanted to say, for this updated draft, a lot of what the legal team did was pull from 050 to bring down to 141. where it might fit slightly better. So you might have seen in the last iteration, something in 050, but we baked that again back into additional requirements for social consumption establishments in 141. So just wanted to kind of flag that for the board's consideration and for the public. Again, we think that a lot more naturally fits under 141, so that was a big amendment in this draft.
Go ahead, Commissioner.
We do need to address the language in transporter, which is 9.
What page are you?
On this, my hard copy here, it's 35, but on your copy, it'll be a different number on the,
It's 35 as well.
you got 35.
Mhm.
So in essence, if I may, Acting Chair,
Of course.
so if we were to strike the provision that does not hold another marijuana establishment license pursuant to 935, 550. That would make it on par with an existing licensee transporter. So former director once shared with me, it should only be marijuana transporter for all of this. Like, essentially an existing licensee transporter can do what a third-party transporter can do, but they can scale and a third-party transporter cannot. So we're removing that provision. So now a third-party transporter can scale. What I mean by scale is get another license. So we can the easiest thing to do is just strike that line. The more complicated thing to do is to make it all under marijuana transporter. Which essentially we're doing that by striking that line.
What line are you referring to?
I'm referring to under 550,
Yep.
050,
Mhm.
on page 35, number 9,
Mhm.
you have the title marijuana transporter. Under that, you have 1 and 2, third-party transporter and existing licensee transporter. So what we're effectively doing by allowing them to apply for a social consumption license type is we're saying, yes, you can hold another license now. So we have to remove that does not hold, you see in the first sentence, an entity formally registered or currently licensed to do business in Massachusetts that does not hold another marijuana service. We have to strike that to be consistent with social consumption.
Well, it's a good point. I guess the question becomes, are we opening up a third-party transporter to also be a retailer or cultivator? I think I think the intention here is that again, this comes out of your suggestion in a previous meeting of allowing a third-party transporter to apply to be a social supplemental on-site consumption licensing.
I'm asked, if I may.
Go ahead.
So I don't understand, but we weren't here when these were stood up, but why does an existing licensee transporter afforded much more opportunity than a third-party transporter when essentially they're doing a similar function? And ideally, I feel there should be some parity there. I think we just strike that line. It will bring some parity.
What line?
The line about they can control. Yeah, like the first line.
Okay.
You can't have the first line and the last line in blue.
Right, I mean, so the options are
The easiest option.
strike the first, strike part of the first sentence. Or add to the first sentence the opportunity to operate as a supplemental on-site consumption license. So you could say an entity formally registered or currently licensed to do business in Massachusetts that may hold a supplemental, or that may only hold a supplemental on-site consumption license within its existing marijuana establishment premises pursuant to 935-500-050 is not formally registered or currently licensed as an MTC. Or that does not hold another marijuana establishment license pursuant to 935 CMR 500-050 other than a supplemental on-site consumption license. And is not formally registered or currently licensed as an MTC. And maybe we can bake it into the language or looking at you. I have to go.
Yeah, I'm just kind of playing devil's advocate, if I may. Is there a reluctance why you wouldn't want them to be able to be part of another license type when an existing licensee importer is able to? Acting Chair, may I?
Go ahead.
Will I read it? So I just want to read the definition of the existing licensee transporter. Existing licensee transporter means an entity that is otherwise licensed by the commission and is also licensed to purchase, obtain, and possess marijuana or marijuana products solely for the purpose of transporting, temporary storage, sale, and distribution on behalf of other marijuana establishments or MTCs to other establishments, but not to consumers.
Acting Chair.
Okay.
If I'll play devil's advocate now. I mean, just listening, I wonder if it makes more sense to eliminate that language completely. Because if someone were to be licensed as a social consumption licensee, they would then fall under that second existing licensee transfer.
Exactly. Yep.
So I don't know if the language is necessary in this provision here. And I'm talking about the blue language.
Mhm.
Oh, wait, sir.
So I'm saying sort of the same, it's a different approach. It would just allow that licensee to be considered, and I'll open that up to staff that are here too. If they are a social consumption licensee, don't they then fall under a licensee transporter? I'm playing devil's advocate here. I mean, the one thing that might be a little bit complicated is the existing word, but there might be a way for us to maneuver that where they then would fall under existing licensee as opposed to third-party transporter. I'm saying that out loud, and I don't know if that answers.
So I think, are we saying the same thing?
I think so. I think I'm just trying to get around to what you're doing, and maybe your way of going is a little bit more simplified than what I'm doing. So I guess I'm trying.
I agree. I think we're saying the same thing. I
Yeah.
think this should be consolidated under marijuana transporter, all under one, because it's just so uneven. The two, and I don't understand the reasoning for that. Doesn't make, I don't understand that.
I can share.
Mhm.
So I want to understand this though, because the idea is not to permit third-party transporters to access every license type. It's only for social consumption.
I think that's,
Yeah.
that's generally what Commissioner Roy suggested in the previous meeting. Should we include them in the opportunity to pursue social consumption, more specifically a supplemental on-site consumption license?
So I guess I can't get past it. So if we eliminated the difference between 1 and 2, that opens it up more. It goes beyond just the supplemental.
I am advocating for that.
Oh,
I am advocating for that.
got it. Got it.
I am.
I got you. Okay.
I just don't understand the rationale. Why these folks are limited to this, where the existing licensee transporter who's effectively doing the same functions are not. I just don't, no one's been able to explain that to me, and I don't understand it.
I see.
So I'm just looking back at existing licensee transporter definition. So there's no prohibition on an existing licensee transporter from having another license.
No.
There are multiple,
Essentially doing the same functions.
right? Not even offering a definition other than right there.
Exactly.
Go ahead, Commissioner. Owens.
Ask. Do you have any issues with us putting it all under marijuana transporter? So we bring parity between existing licensee transporter and the third party folks? Do you have any concerns around public safety or any concerns that you can think of?
If I may.
Chief, go ahead.
No, we do not. No, we don't have any concerns at all.
Um, what I might suggest is we probably would need to do a little bit of wordsmithing on this. And since it's likely we're gonna have to roll over into tomorrow, try to think of some opportunities, come back with some language that would consolidate these two.
So
Did you say, go ahead?
thank you. So the direction that seemingly there's consensus, I just want to summarize to make sure I understand. So it would essentially be to collapse both license classes into one license type, marijuana transporter. Okay, who would be eligible for a supplemental on-site consumption license?
Well, just based off of this, a marijuana transporter, because they're can either be a third party or they already have a different license type. So it still would capture our intent. And hats off, Commissioner Roy.
Thank you, Commissioner Concepcion.
Okay.
And do you want to assign that to anybody? Do that, Chair.
Deputy GC, go ahead. What are your thoughts?
I wonder if, 9A, the way it reads, you could almost put a period at the end of that. And then keep the sentence that's in blue as a second sentence under A. And then essentially eliminate the 1 and 2 language as it exists there. I think we're probably gonna have to have some language that ultimately will account for existing licenses and how it will have to convert into another, the transporter license in general. So I'm happy to work on that if that sounds okay.
Yeah, thank you, Acting Chair. I think I'm trying to understand the rationale behind this, and I think it might be because there needs to be a license type for those entities that only transport, and that's why it's captured here the way it is. I just would imagine that because without it, we're not speaking to licensees that only transport. So I was thinking this through, that the rationale for including the separation language is to capture those entities that only transport. So that are not carrying any other license type, but only transport. And I guess I'm concerned about the removal of language that speaks to only those licensees that just transport and don't do anything else and don't have any other license types. So that's just my way of saying, I want to make sure that whatever language we receive back with any sort of drafted language, just make sure that we're still capturing not just the universe of licensees that carry multiple license types, including transporter, but also those licensees that are only transporters. You understand what I mean? Because third-party transporter speaks only to entities that only transport. The second one, existing licensee transporter, are speaking to licensees that do more than just transport. So without that definition for third-party transporter, we do not have anything that captures that universe of licensees that only transport and don't do any other kind of license type. I can rephrase that too.
No, I understand what you said.
Sure, Roy, go ahead.
This question is for ID. So if you go through 500.050 and it lists the different types of MEs. So technically by number, so the above it, number 8 is a retailer, number 10 is a courier. So it lists, so the license type is a marijuana transporter.
Yes.
It's kind of a rhetorical question, but thank you. So, okay, so we're not changing the name of the license type because it's called a marijuana transporter, even though we in my mind, I know I've always said third-party transporters is a license type, but technically the license type is a marijuana transporter. Is that accurate?
So yes, the license type is a marijuana transporter, but they have different prefixes and metric to denote which one is which, whether it's existing or standalone. MX and MT, and that fall their license numbers as well.
What you said, MX?
Yep, MX and MT. So one is a marijuana transporter, one is a marijuana transporter with existing licensee. So what would integrate with metric in terms of their license type and their specific license type and their license number.
Thank you. And so may I? So those, stuff with the prefixes or stuff at the beginning.
Right, so like a retailer's MR, blah, 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 MX.
All right, so the prefixes. Yeah. So how does the commission determine which prefix to attach?
That would be part of their application.
So that wouldn't change.
For those existing, for licensees we have right now, say,
So they could have their prefixes still.
so if we were to combine it into one, we no longer have existing, it's just, we would need to speak to metric in terms of updating that, because if there's not gonna be a purpose to have existing or standalone, probably wouldn't make sense to have two prefixes.
That's to your point, Commissioner. Okay. Do you see a problem with that?
If I may,
Without the prefix?
yeah, it would require configuration. We'd have to speak to metric to even see before we can even respond to that question. And then we also have to touch base with Paul as well, because I'm not so sure how that would work out. Because from our end, it might seem simple, but then we don't know how it's going to be for metric, because they are the ones that have to do that configuration.
Okay. Okay. So okay, so the easiest path forward then, if we just remove the requirement that they can only have one license type, but to Commissioner Concepcion's point, keep the subtitles, that wouldn't require any kind of reconfiguration.
No, it would not. I mean, I think as long as the language is clear here, we'll keep things as they are
Okay,
in metric.
okay.
But I'm also trying to think if there'll be any other updates that will be required if we did change this. Let me look at the guidance documents for a second. I just want to check something.
Right.
Yeah, I was checking to see if this would require for us to update our guidance documents, which would have to work in conjunction with, for example, if it's a situation where you change the definition and everything, would have to work with the legal department to make sure that any guidance documents that we have on their party transporters are updated.
Right.
Right.
It's gonna be a lot of updating of guidance documents.
Ever?
Yeah.
Right.
One other consideration is, thank you, in 005, and thanks to Jess Porter for pointing this out, there is a $500 difference in application fees between the two, so we might want to figure out how to amend that if we are conflating them.
Okay. Commissioner,
Okay, thank you. I'm throwing out something. Because it might make more sense to create an avenue for the third-party transporters so that go into the existing transporter. I wonder if that might be an easier remedy than changing, doing a more broad-based change. Because essentially that's what all we're doing is we want to allow the third-party transporters to access a license type
Right.
and open up the license type for other variations. So if we were to create some language under 2 and change that a little bit so that third-party transporters who want to obtain an additional license would then fall under that umbrella as opposed to being considered third-party transporters, I think that might be a better way to go about it. Yeah, and then we're still getting the universe of third-party transporters that just want to do that, period.
Yeah. If I may, yeah, so maybe that would make sense, maybe even under this, I'm looking at, where we are right now, under this subsection, it's just adding language, basically saying now they're allowed to.
That's right.
That's right.
That's right.
And then for our purposes and for metric, even the way that we would describe them though, it would no longer be that third-party transporter. You would then be considered this, I forgot what you said, Catherine.
Existing
Yes,
licensee transporter.
right.
Exactly. Yeah, that works.
Just adding a subsection under that.
Dragon Chair. So Commissioner Concepcion, are you willing to work with me on the language for that? All right, perfect. Let's do that.
Commissioner Rinka.
Thank you. And thank you to Jessica for flagging that. I'm looking at that now, the fee structure. So the existing licensee transporter has $500 less of an application fee and the transporter has $1,500. So we need to decide which direction we go down in fee for them. That's on page 22 on the.
Commissioner Roy, I wonder if the change is still necessary, considering the direction that we're going in.
Oh, I see what you're saying. Like if they choose to stay as it's just that, they continue with that fee.
Right.
If they choose to segue into the existing, then they
Subject
would
to the new fee.
reassess the new fee. Okay.
Would also, sorry, they would also be assessed the supplemental consumption.
Right.
Right. In addition.
I just, so we leave it in the place. So we're gonna add language to under 2.
Yes,
Yes.
so that blue, sorry, I can chair.
Go ahead.
The blue language wouldn't be located where it is now.
Okay, perfect.
Because what you said was accurate. That made so much sense that if we're putting that language, it contradicts each other.
Yep, perfect.
Anything else under 050? Go ahead.
Okay, on page 38, the delivery operator, just to Commissioner Concepcion's point. I would eliminate that ice cream truck scenario because we put premises. Correct?
Okay. last
Okay,
one.
oh, yeah.
Yep.
Okay. Yes,
Second, right.
yep, okay.
Only thing, moving along. Obviously, 101 gets to application requirements. I just noted as we move through that, we're making appropriate references to requirements to demonstrate how they plan to prevent both diversion and inversion. Next thing I would note is page 47. I think this is new language at the bottom. Number 5, Deputy GC, if you want to just walk through that with us. I know we talked about it before, but I think it's important for us to, for me, it was important to circle back and just touch on.
For subsection 5 there.
Yeah.
Applying marijuana establishments applying for supplemental on-site consumption license with the same persons or entities. That's the one you're reading from.
Yeah.
Same persons or entities with direct or indirect control shall not be required to submit financial information and background documentation of owners in its application. I think there's a number of ways that this package tries to reduce the overall burden for licensees, and this would be one of the provisions that would be trying to get at reducing the costs overall of the application process. So I think that was why the provision was there initially. I have one point on this section though. Appropriate. So for 8, what folks will see is that language was struck under this current draft. What we tried to do is the former commissioners had outlined a number of application requirements for summaries that will eventually be full SOPs, but because we are really building out 141.2, which is the SOP section down below, we thought that it would be best to require licensees to just summarize those. And so we struck the former commissioner's language and included new language, which again would require licensees to submit summaries of the eventual SOPs that we'll have to comply with. Trying to again streamline and marry the two. There's, as I had mentioned on the outset of rolling this regulation out, that there's a lot of SOPs these folks will have to comply with. And this was one way of trying to reduce some conflicting language that we saw in the last draft.
So it's not that this is being deleted and not replicated anywhere else. It's just being built out in the 141.2.
Exactly. So folks can go down to 141.2 and you'll see all of the SOP requirements there. And then that way they just have to look at that section in order to really build out their SOPs.
Okay.
I should say that there's general ME SOPs that they also will need to comply with in a different section. However, for social consumption establishments, it's at least all housed under 141.2.
Okay. Commissioner Rourke.
Deputy General Counsel, my understanding of 8, this is part of the pre-certification process, application process. So they just need summaries for that.
Yeah, essentially the logic there being, again, this is a requirement. Summaries are a requirement in 101. But this way we are marrying 141.2 in this section so that every SOP that will eventually have to be developed for you to commence ops, you'll give us the summary upon your application.
The next item I had is down on
If I may,
Go ahead, Chief. Court.
Attorney Baker, going back to the language about summarize, so is this in addition to the actual SOPs? We want to understand, so if it is, so the application, they would only be required to submit just summaries? And then do they, I know you mentioned that we have the specific SOPs that they need to provide. do they then have an opportunity to provide the actual SOPs to the commission prior to final licensure? Can I ask why, if they're going to provide us with the actual SOPs, why then are we requiring that they provide us with a summary as well? Wouldn't that be duplicative of additional work for the licensee to provide summary and then the SOP?
I understand what you're saying.
Yeah.
The way that it was drafted, I think you could look at it as a buildup of getting to your full SOP, of you providing the summary, which would be essentially like the draft version of what would inevitably become a full SOP. So, but again, it's to the board. If the board wants to require full SOPs for all of these upon application, they could do that as well.
Acting Chair.
Okay.
Oh, actually, Commissioner Wright got her hands up first.
What your team goes through now.
From licensing all the way to final.
No, I mean, with around the SOP.
Okay.
Are they seeing summaries now, or is it just full SOPs?
So we want full SOP right now.
Summary is not of little use or no use.
Right, because the point is that for us to deem them, either
Compliant.
deem them compliant, we need to see the full SOP. So
Right.
having summaries, that's like a partial to us, that's more of a partial draft.
Yeah.
And then now what would require is that it would have the team reviewing the summaries and then having to review the actual, that's duplicative.
Yeah.
And I think it goes against the grain of what we're trying to do here, which is to determine compliance. That's why I had to ask that question before we went further, but I think,
I see your point.
Mhm.
It's gonna create a lot of back and forth.
yes.
This draft is an incomplete picture, and you're gonna say it's not compliant,
And then they'll say, we're just providing you a summary. because we're
Summary.
the regs.
right? And it's gonna go create a back and forth
Mm.
unnecessarily.
Mhm. When we can actually,
Yeah, I hear you.
look at the SOP
Full
itself.
SOP.
Right, and then determine if there's a need for us to request additional information or not.
I hear you.
Acting Chair. Because it's at the pre-certification phase, I think just because I'm, it's early on,
Right.
you still have a long ways to go through our licensing process. Do we want to require an SOP at this stage, or would we rather? I guess there's a few different things here. So as it's stated, this would require a summary. Another option is either or, a summary or an SOP. Or would we require nothing? Or I guess I'm trying to understand what sort of requirement are we putting out there at the pre-certification phase?
I will defer to the director of licensing what your preference is, because again, as we go through the different stages from application all the way to, the inspection part of it, it changes. So I think that's what we need to coordinate right now.
I'll ask another question that might make it easier for me to understand, because we already have the pre-certification process in place.
Mhm.
So what do we require now? Do we require summaries? It sounds like we don't.
So currently in the application process, we ask for their plans to their SOPs. So it's not the actual SOP because, they might not know,
Right.
maybe too early in the game, to your point, that they don't know the actual SOPs. But once it reaches Catherine's team, they need to submit the actual SOPs.
Okay, I think, I'll keep on going, but I don't want to deviate too much in the way that we
Yeah.
conduct business. So it makes more sense to have this be similar to the way that we're already doing business under the pre-certification phase. So I guess that's my suggestion, is that we just follow the same thing that's already being practiced, so we're not complicating things.
Just to reiterate, so the language as you see it was initially summaries upon the initial draft from the former commissioners. So, but what we're doing is really expanding what is required for SOPs. So again, some of this language was really duplicative of what we were already building out in 141.2. So again, we try to keep it consistent in so much as I didn't amend summaries here as the former commissioners had laid it out, but definitely understand the chief's point of view here relative to providing full SOPs, but I think summaries at that initial.
But I don't think that's where we're That's not where we're landing. I don't want to call acting chair. Do you mind if Chief Jones?
No, go ahead.
Mind.
Go ahead, Chief. Sorry,
That's okay.
I told you, you can yell out at me if I don't see you raise your hand. Go ahead.
No, yeah, I think, what we can, my suggestion would be to keep it consistent with our current processes. It makes sense. So instead of saying summaries, because this is going to be a new license type per se. So we want to, let's just say plans, if that's the case. If the team is already looking at plans right now during the application of recertification, let's state that instead of saying summaries, because I can see that it could create a little of questions and all that. So yeah, to keep it consistent with the plans.
And by the time, when it gets to the provisional phase and it gets to the board, all of those SOPs are in Mass CIP. We see them all, we read them all. So we will have access, the board has access to full throated SOPs by the time we vote on this license.
Correct.
And as long as that stays consistent, that's how it works now.
Right, how it works now, by the time it gets to the final license, the investigations team, they've met with them, had an interview with them, asked them questions, reviewed the SOPs and everything else. So by the time it gets to the final license. So when the board votes on the final license, those SOPs are in place. We have, copies of them.
So it sounds like we're leaving it the way it is.
No.
No,
No,
No, we're getting
Summaries.
Summaries are out.
okay.
What is?
oh, I have to check, let me see something.
I hear our ED question.
I mean, I think the directive is clear that we want it to be consistent. We're just looking at one thing elsewhere. And I can follow up afterwards if you'd like to move on.
What are you checking on?
Just if the word plans is used instead, just so we're consistent.
No, we were checking, the EDA has to check to make sure that summaries is not used elsewhere. So far, I only see it being used in that one, in that subsection A. They have it as summaries, so we'll be replacing with plans. So let's check for plans to see if it's used elsewhere, but yeah, we have about, results related to plans, but I say strike through them for the word plans, but it's not defined. But I think in this we're able to actually replace summaries with plans so that it's consistent with what the team does.
Sorry, your point, sir. Tweaking A summaries to plans.
So that's what the Chief Jones and the Executive Director pointed out is if we actually use plans in the pre-certification context that exists right now in our current regulations. I'm looking through it now, I don't see it. But we want to mirror that. Go ahead, Chief Jones.
Gotcha.
So the word summaries, so far from the search that I did, is just used in one area. That subsection that we're looking into, that's the only place where I found summaries. Unless if somebody else finds summaries elsewhere. So the idea is to replace it with plans, right? But also the ED wanted to check to see where else do we use the word plans,
Right.
right? Which, from what I see from my search here, I see that the word plans has been used 34 times, but I see strike through, some strike throughs, from the version that I have in front of me. But also we have to remember, like, for example, we have architecture review plans. It depends on the context of which we're using it for.
Sure. I think where I was looking is the existing language under pre-certification, and it doesn't reference plans within it. It says what an application should consist of, and it breaks down the different requirements. But the term plans doesn't, it's not there. I think, see, I was eavesdropping. Executive Director, I believe what I overheard you saying is that you understand the intent, so we'll try to get some language that mirrors the existing pre-certification requirements for some sort of plan.
Right, I think the point is summary doesn't work. Plans is generally what is being considered, but we just want to make sure that the language is consistent with the other practices and make sure that that's the way it's so that summary is replaced with the correct word. We'll do that separately and bring that back.
Sure. Let's take a 5-minute, a little bit longer than a 5-minute break. Come back at 3:20.
Bladder thing.
Charles.
It's my bladder. Yeah, and then I think you get it. Oh, so.
All right, reconvening, picking up on page 48 and any changes to that language there. Commissioner Concepcion, you were looking at some of the other additional specific requirements.
So I was looking at the language that we already have in regulations around pre-certification to make sure that we're capturing the same concept around a plan. And after speaking with Deputy General Counsel, I believe if we put plan here, it would capture the intent. And then if we need to change it down the line, we can make the necessary changes. If everyone is okay with that.
May I ask?
Yep. Go ahead, Commissioner.
So Commissioner Concepcion, you're proposing we strike the word summaries, replace it with plan
Yes.
or plans, plural?
Yes.
Okay.
Okay. All right. I think the next spot to jump to was top of page 51. Page 52 for me, that this is under final license. GC, Deputy GC, you want to just walk through the changes there, the letter subsection G, that language?
Yes, thank you, Mr. Acting Chair. I worked with Enforcement Council to think about the last conversation that we had relative to retailers and shelf-stable products. And this was one of the considerations stemming from that. And we do make amendments in 500-140 that also speak to what is allowed at retail. But this is one of the amendments. So Commissioner Concepcion, this would be partially speaking to your consideration from last meeting. However, the full consideration is under 140, not here.
Acting Chair. So the phrase branded goods, that is the phrase we're using to refer to shelf stable items. I think I'm looking at the wrong thing.
I'm sorry, this is the prohibition that you were seeking.
Yeah, I think I'm on the wrong. It's on 52.
I'm on 51 of the red line version.
Yeah.
Good first language on the page of 52.
Right. So that was my question, because it says, unless authorized by the commission, a marijuana establishment may not sell any service or good other than marijuana products, marijuana accessories, and branded goods. So is the phrase branded goods referring to shelf stable items?
No.
No.
Branded goods
No.
is its own definition.
So then,
So we're going to find shelf stable in another section.
thank you.
This is just getting to.
This is that proviso you wanted. We want to make sure we have that there, so we're not
And
selling bars and
That's
stuff.
great.
And the reason why we're putting it here is, again, this is under the final licenses section.
Okay.
So we wanted to make sure that it was included there. However, there are considerations for what is allowed at retail sale under 500-140. And that's where we speak to the full provision relative to the discussion at the last public meeting.
Thank you, Mike.
Next, I think we want to jump to, we are seeking to incorporate some changes into wasting. I think that starts somewhere on page 71 or 72.
Yes, thank you, Mr. Chair. I could definitely use some background context here for the Director of Investigations and potentially Enforcement Council if they're inclined. There's a couple different amendments that we have under 105-12A and 12C. These are considerations that speak to try to clarify some issues that we've had relative to waste. So we strike some language under 12C, which would leave it so that you rendered unusable the product, or excuse me, I gotta get onto the page. But ultimately, I think this will help clarify for licensees and our enforcement staff about what is required for waste.
Any thoughts on this section? Obviously, it's changing up some of the, again, the recycling language, trying to be clear in terms of rendering any marijuana or marijuana product unusable for its original purpose. And then obviously, one of the big changes under T is moving to a single agent being required to witness and document how the solid waste or organic material containing marijuana is rendered unusable. If I'm correct from our conversations, WGC, using that rendered unusable was moving away from necessarily the sense of or the practice of grinding to handle other material. That's Director Bidkowski, please.
Thank you, Mr. Chairman. Yes, so some of the updates we put in this section is meant to kind of clarify expectations as well as make it clear for my team as well. A lot of these definitions were kind of lifted and shifted from DPH when flour may have been the product that was being thought of primarily when wasting. The prior definition for subsection, was it solid waste? So is that subsection D, C? Just included grinding. For certain marijuana products like edibles, gummies, vapes, you can't really sufficiently grind them. It can gum up the machines. It doesn't necessarily render them unusable. So that was really struck just to say that it must be, shall be rendered unusable for its original purpose. And that gives some flexibility to the licensees while also still letting my team determine compliance. And then for subsection D, to be in line with prior discussions with having dropped down to one agent, since it has to be under camera coverage, and just putting rendered unusable in there as well. We did keep the grind language in C subsection 2B, since that is organic material, so that would be the flour. And we will be developing kind of additional guidance on this to provide further clarity to the industry as well. We've gotten some questions on whether it requires mechanical grinding. The regs just say grinding, so there is some flexibility in that, but the purpose is that once it is destroyed, rendered unusable, whether it's mechanically ground, manually ground, it cannot be used if anyone had access to it.
Thank you. I'm glad we can just this regulatory round to kind of clear it up and offer a little bit of relief in terms of only having one agent being required to witness. Commissioner Roy.
Thank you. And speaking of offering relief, I just have a question for I&E. Is there still utility in the minimum 3-day waiting period after you receive commence operations? Or is there utility or is there not?
Commissioner Roy, we have I&E's position is we felt that because we did look into the historical context of why.
Okay.
I think at the beginning it made sense, but with where we are now, we don't see
There's no utility in it.
We had looked into it before with the previous with the AED in terms of changing that. So whatever the board wants to do as far as that is concerned,
If I may.
is proceed.
Sure, go ahead.
So my understanding of the historical context it made sense at the time because there were huge traffic pileups. There was, right, you had to have, local, make sure there was local traffic police or details there. So it did make sense, but we don't have that anymore. And if someone got to commence ops and let's say it's going into a holiday weekend or they're in a tourist area, like it is, it can be detrimental to the licensee to lose those 3 days if we don't need it. So I'm wondering if we're at a point in the commission where if INEC is no longer, there's utility in it, maybe we can relieve that. Provide some relief there for that.
Yes, Commissioner Roy, we definitely agree. That's why we had raised it last year. Because we did, from an implementation point of view, once we've issued them their commence ops and they have the notice. Yeah, so we have done our inspection, we've looked to make sure that everything is in place. So at that point, once they receive, it's a business decision whether they want to start the next day or whenever they want to. The 3-day waiting period, we have seen that it has an impact, especially some people, they miss the holiday sales, right? And all that. When in fact, they might have a lot of people coming in from like, especially with tourist areas. There are people that are there around that time, and then if we're making them wait for 3 days, then they're not able to open or make sales because of the fact that they have to wait for 3 days.
What do you need from us?
Ah.
If my colleagues are inclined.
I think, if the board moves to change that, we had sent an action memo to the executive director. I think if the board does move towards that, it's just a matter of coming up with some motion language that speaks to what the board's decision, so that moving forward, we all know what's expected as far as the 3 days is concerned.
Chief, go ahead. No,
No, I'm all set, thank you.
okay, okay.
Man,
Go ahead, Commissioner.
something we should do while we're doing this or at next public meeting, or what do you recommend is the best course?
What I recommend is the best course is so that we can have a moment to discuss with the ED, because he hasn't had that opportunity.
Yep.
If you could please give us time to do that, so that he familiarizes himself with that process of what it looks like now and everything else, and just give him some historical information and also provide him with our previous action memo. That way, when if you do have this on as an agenda item or decide to discuss it at the next public meeting, he would have that information, and also for the legal department as well, to give them time to be able to come up with some motion language, if any at all. I think that would be helpful. Mhm.
So we can, thank you for bringing the topic up. We can look to see if we might be ready for the August meeting or the September meeting. All right. Moving down page 73 and reporting requirements.
Sorry, Acting Chair.
Go ahead.
I just got information from the team as well that from one of our inaugural investigators, that this was also a prerequisite from the municipalities at the time to have the 3 days. Right.
Bit of info. Okay. I thought we were moving down there. Deputy GC, you have something on page 73? Did want to make sure we get to it. It's
No.
not reporting on page 84 was the next thing I think I had done with.
Yeah, that's the next amendment, Mr. Acting Chair, but I don't, obviously you see diversion and inversion amended throughout, so sorry for including that in my list. I don't think we need to review it any further.
Won't hold it against you. All right. Down to page 84 again, this was suggestion or addition or amendment by I&E with respect to incident reporting. Invite I&E if there's anything that they want to have, but it's on page 84. 9, incident reporting. Just, I see it as just kind of clarifying who public safety personnel are and further defining it as any federal, state, or local personnel that are involved in any type of response to an event, a public safety or an alarm activation or other public safety event. Director, you want to give us a little bit of the background on the language and why it's important?
Thank you, Mr. Chairman. Yes, so this was meant to kind of expand upon instant reporting requirements we already have, but also to clarify it. The prior language just said an alarm activation or other security event that required a response. And we had a broad interpretation of that. Some licensees expressed that being unclear when they would get deficiencies for not reporting certain responses to their facilities by us. So wanted to clarify if public safety responds to the licensed premises, it would certainly be applicable. And then we also built out, we added in 2 more subsections, 10 and 11. So 10 is any medical event or health and safety emergency that requires response by applicable federal, state, or local personnel. And then 11 is any notice issued to the licensee from those personnel indicating the licensee received a complaint or cited violation. And that is just so if we have joint jurisdiction, we're looped in on any compliance violations. They're held to by their municipal officials as well as our partners and other state and federal agencies, just so we're aware of anything going on. And that will help us as we work with DPH, OSHA, other kind of sister agencies in that regard.
Any questions on that section?
I do have a question. I think I am trying to land on the utility of the phrase applicable here. I feel like it might cause some confusion in practice. So I wonder if we can eliminate that, if it would still meet the goal that you're trying to reach here.
Yeah, if we strike applicable and it just says federal, state, or local personnel. I think it's pretty clear who those public safety personnel would be, whether it's state police or, federal law enforcement. I'm fine with that.
Don't want to cut anybody out of the action. So remove applicable.
Applicable is also in.
Applicable under 10.
Yeah.
It's not in 11. Okay. Okay. All right. Now I think we're moving into 141, if I'm not mistaken.
Before that,
Before that, yes, before that, page 93, I guess.
thank you. This is the language that's responding to Commissioner Concepcion's and Commissioner Roy's points at the last public meeting.
Oh,
Three.
sorry.
No. Where's
What?
page 93? This is the sale
Oh, yes,
of benefit.
question.
Okay. I only had an appraiser with you, just the language under E, marijuana establishment may sell non-infused food and drink items that are prepackaged and shelf-stable. The next sentence, the marijuana establishment may seek all licenses and permits as necessary.
Shall.
Should it be shall or must?
I don't think that you need a license to sell shelf stable, so I don't even think that you need one.
Yeah, but this might be driven more by the local level. I mean, like a common vic license. I don't know if they would need that if they're selling local items, whether it's, I mean,
I can share if I may.
Go ahead.
I agree with you. I think as necessary covers when it's not necessary. So if it's not required, then you don't need it. But if it is, putting shall instead of may would cover it.
All right. Commissioner Ray.
My question on E is the term marijuana establishment. That what we want as a board, or do we want it marijuana retailer? Because there's a difference, obviously. Like an ITL could sell. I think the goal was to bring parity with the retailers and the social consumption. Because it's direct to consumer business, so to speak, but I'll defer to my colleagues, but I don't know if we want it retailer or establishment.
I understand what you're saying, Commissioner Roy. I think we want to make sure we're also capturing social consumption sites too, but I get it. Like, you don't want it to apply to every.
Unless we do, I don't know, I don't think we do, but unless we do. I think we do. But it would apply to everybody if we do it like this. Unless we, we can be prescriptive. Marijuana social consumption site, licensee and marijuana retailer may sell.
Yeah, that's getting more prescriptive. Somebody knocking in the door of the cultivators. You guys see chips?
I want chips and cracker jacks.
Tortillas.
No, thank you, Chair.
Skipped over you.
Oh, no, Catherine, DOI to cover that part, fine. I understand Commissioner Roy's question, but it's kind of presupposed that obviously cultivators and product manufacturers are never selling directly to the public. So I understand Commissioner Roy's comment there. But I do think it's kind of inherent in the license type itself that, and hopefully the public and our licensees understand that again, the only direct sale to a consumer or patient is not going to be happening at a cultivator or product manufacturer or an ITL for that matter. So I think it's kind of automatically cutting out a certain number of those license types, but specificity never hurt, so.
Deputy Juicy.
Thank you, Mr. Acting Chair, and Commissioner Wright's an extremely good point, so thank you for raising it. I think the way that this language would read right now, someone like a marijuana delivery operator would be able to sell shelf stable. So right, so definitely an important point for you to raise here, and ultimately defer to the board if that's the intention. So I think restricting it to marijuana retailer is probably more in line with the conversation that you had.
It is.
From the last round, last regulatory conversation.
So you want to change it?
Well,
specific.
I don't want to mislead, like intent was bringing it up was for social consumption and retailers to be on par. We didn't really, our conversation didn't contemplate any other license type, but we all spoke last on this.
So the question kind of becomes, do we want to extend it to a delivery licensee or a delivery operator?
Right.
Or specifically, probably a delivery operator.
What are your
Yeah,
thoughts,
this is
Mr.
sort of-
Concepcion?
I feel like you said something that made me laugh. You just said, or maybe we do.
Maybe we do.
No,
Maybe we do.
I don't know.
Benefits of the open meeting law.
Yeah.
I guess we haven't really honestly, if anybody wants, we have not thought of this. I mean, do we want the delivery operator?
I'm hearing you in my mind too, because you earlier you said parity, and I'm like, parity. If we're thinking about that, then yeah. I guess I would pose the question, why not? That's what I'm going through right now is, what are we?
We're gonna hear.
Director, yes, Steve, do you have a thought?
I did, it was a little, it's related to this, but I was seeking from Deputy General Counsel a little more clarity on the official definition for shelf-stable food. It says it does not include time temperature controlled for safety food as adopted under 105 CMR 590.001A. Can you just kind of, in layman's terms, just kind of explain or break that down? What does that specifically mean?
Yeah, sorry, multitasking.
Okay.
You're reading from the 141 section.
41.3.
I was just referencing the definition.
And
Yeah.
O2.
Yes, shelf-stable in the definition, yes.
So, your question is, what does that mean?
Yeah, exactly. Because it seems to be a direct quote referencing the, regulations in 105 CMR 590, the
Right.
adoption of the 2013 food code. Just kind of looking for some clarity, because I understand, obviously, stored in room temperature in a sealed container, got that. Was just a little confused by the remainder of that definition.
And once I'm gonna pull it up.
Sure, thank you.
It's on page 17.
Yes.
Commissioner Roy, go ahead.
If we decide to keep in marijuana establishment, then we have to adjust F to say marijuana establishment, not just retailer.
So, Mr. Acting Chair, if I may.
Of course.
The second sentence here, time/temperature controlled for safety food, is referenced to the CMR later in that sentence. And again, that's under DPH. The reason why we're striking the 2013 food code here is because that is going to be updated soon and will be incorporated of CMR 590. So it's going to be outdated if we left it in there any longer than it is right now. But time and temperature controlled means essentially that you can leave it in room temperature and not have that food go bad, just leaving it on the shelf. So time, meaning that within 48 hours, it's not going to go bad sitting on your shelf. And then temperature controlled, meaning it doesn't have to be in the fridge in order to, remain edible. So that's how I would look at that sentence.
Okay, thank you. Okay.
And then also just to clarify, when we bring up 141.3, I do want to offer an amendment to the shelf stable language there. So I don't want to get too far into that conversation until we get to 141.3, because I do want to offer some tweaks to that language there.
So the question, I think, coming back to what you're pondering is, do we want to expand it to marijuana retailer, marijuana consumption establishment? Who else in the universe? Do we want to extend it to delivery courier and the delivery operator?
So I was just looking into what the requirements are, permitting requirements. I use Boston as an example because that's where I'm based. And if someone wanted to sell shelf stable items, they would have to go through the Inspectional Services Division. And I think that there are other municipalities that might have similar requirements, because my mind was going into, okay, how would they be permitted?
Right.
Who is reviewing this? How do we make sure that there is a checks and balance in place? Because this goes a bit beyond the scope of our team here.
Right.
Then my other thought, so I'm okay on that front. My other thought was, there'll be, I would imagine there may be some pushback because now we have licensees competing against other businesses out there. There's one in particular when I think about delivery that caters specifically to the same consumers. But it does open up an opportunity for increased revenue for our licensees.
Another revenue stream.
So I'm having and maybe it's a good thing, I'm having a hard time finding the cons as it relates to our work here and the licensees. So that's what I'm trying to land on. I see our executive director has his hand.
You did, go ahead.
Thank you. Just I had the same general thoughts from a municipal perspective. So one of the things I've found interesting is, specifically what we've defined here that the DGC just ran through. DPH does not take a stance on, right? A Home Depot that sells these products is not under the purview of DPH in that instance, but any given municipality may have their own zoning or regs that puts it under their Board of Health, for example, Boston being one of them. And additionally, I think that the acting chair mentioned earlier that a lot of municipalities in these instances, if you're selling a product, even if it is in this category of shelf stable, that they can have in their own bylaws regulations about a common vic license that would make it need to be approved by the local board, generally a select board or council individuals. And so there is still some municipal control should a municipality determine that they don't want one of these businesses to avail themselves of something that you're considering giving them the option of having. So municipalities theoretically, if they disagreed with this, would have an ability.
I wonder, so one a thought that I have is that we have some language in there, some qualifying language that says prior to the sale. So in that same E, where we're saying that we're saying they shall seek all licenses and permits as necessary prior to the sale of shelf stable products. And then that way we're capturing the municipality perspective. But I'm sure we'll hear comment on this, but I can definitely see this as being something that would be welcomed by licensees.
And so we're gonna leave it ME?
I agree with leaving it as ME.
Okay. So then the next one.
My only concern about leaving just for ME is now expectation of a cultivator, expectation of a product manufacturer, who again aren't selling direct to. I think we can be specific, and again, come on, this is a drought. We're going to get lots of feedback on it. I'm okay with a marijuana retailer, social consumption establishment, perhaps a delivery operator, only because a delivery operator has a brick and mortar facility to actually store shelf stable products, where unfortunately a delivery courier licensee perhaps does not. So leaving it maybe just those three license types at this point, or again, to put it out and invite comment and reaction.
I'm not opposed to that.
Director Pinkowski.
Thank you, Mr. Chairman. And just in terms of from a compliance standpoint, whichever way the board votes, just my team would need really clear parameters that this is essentially something outside their jurisdiction. If there were to be consumer complaints or patient complaints for like a food item that was purchased there, for example, that's likely going to be something that comes to the commission just because it's where they purchased it. So just to be clear that would either be referred to DPH or I think from what we've heard is if you have an issue with the product bought at a convenience store, a lot of the time you just need to contact the manufacturer of the product, for example. So I just want there to be parameters or I guess an understanding that would kind of be outside the compliance, outside of, having the separate accounting practices, because that's still required. They're also required to limit waste, litter, et cetera, on site so that there's no pests. So if there's any type of either municipality imposed or other imposed requirements for how they're storing the food or product, that would just be something kind of entirely my team wouldn't touch.
So I also think about some of these questions as it kind of gets back to a conversation we had a long time ago with respect to the lottery about access to the property, access to obviously protected spaces, like you wouldn't want probably somebody from the local board of public health walking into a vault if that's where they decide to keep their chips and other items. So being clear as to, I guess, a little bit of delegation of authority or responsibility or something that Director Enos.
No, thank you, Acting Chair. And kind of to build upon the point that Commissioner Concepcion brought up before, again, if various municipalities are going to have different degrees of permitting, some heavily, some not at all. Again, we're trying to obviously get to a most consistent approach that we can, unilaterally apply for all our licensees. This inherently is going to have some variability between it from municipality to municipality. Again, training our staff then about that to some level on that, updating our SOPs on that. And again, on my previous point about the specification for the license types, while again, we understand certain license types are public facing, selling to the public and consumers and patients. If we're not specific about it, again, hypothetical, a cultivator then reads that and says, well, I'm a marijuana establishment. It says I can do this. So just curious to know kind of what that pushback will be there then. And to DOI's point again, then working with our other sister and brother jurisdictions and agencies in the state, who's going to be taking the lead on that? How are those complaints going to be made? I can already see food items at one location kind of traveling around and being found in another location. So it's going to be a lot that we're going to have to work in there to update our staff and our team as well. But I think just the inherent variability, municipality to municipality, will present additional workload for our team.
May I ask, Director Enos, how are you going to handle it with social consumption? Because that's going to be mandated. It's must provide access to shelf stable. So it's happening.
Mhm.
How is your team going to handle that? It's happening with social consumption.
No, absolutely, Commissioner Roy. It's something we're looking at now. It's something we're going to have to handle. I think my point is the universe of social consumption MEs is obviously much smaller than total MEs in general. So that was my only comment with more specificity regarding that one provision if we're kind of looking outside of the range of just social consumption. But obviously for our social consumption licensees, yes, this is something we are going to have to look at as well.
Yeah.
Another thing to bring up with shelf-stable product are allergens. I think that's something we need to think about. That's something that's going to require probably additional consultation with DPH, potential Board of Health. But if we're now telling licensees that you can bring this stuff in to sell, there is a host of potential allergens that you could be bringing in to same well. Again, our products and our marijuana have allergen warnings on there. You have to state what's on there. But we might have concerns now where are we going to now require any food item you bring in has an allergen warning on it? So that's kind of how this could kind of expand and require a lot more work on our end.
Are you going to have to visit that for social consumption? Because the allergens.
Absolutely. Absolutely.
Yeah.
So now if we're looking at not just social consumption, but MEs in general, it's obviously going to expand out that search.
And so if we go with Commissioner Concepcion, Acting Chair Stebbins' proposal, where it is retailers, social consumption retailers and delivery operators, that cuts the pool down to 400 and something versus 700 and something. If we go that.
Given your hand up. Or
Yes, thank you, Mr. Chairman. Yeah, I'm covered most of it. There was more so, if this was specific to social consumption. So obviously a license type that's not online yet, we have some time to build in those SOPs, what that's going to look like. As Armin mentioned, our products are required to have allergen warnings on it. So if, that product would be outside of our jurisdiction to an extent, is there going to have to be signage, for example, if you go into social consumption, that if there's any allergens on site to let the employees know, to let the consumers or patients know. And, that is something that is required on marijuana products at this time. And certainly our manufacturing licensees, there's ServSafe, there's food safety handling. Not that would necessarily be applicable to selling the products, but it's just additional. There could also be blind spots to our licensees selling these products now that we're unaware of. Our retailers in other licensees that are currently online, we're not going to have that time to build that in the same way. We are going to be able to talk to different community stakeholders with social consumption. If it's just across the board, they can sell any shelf-stable products, then they can just sell shelf-stable products, and we're just gonna have to determine who those complaints or issues are referred to, and it would likely be the municipal boards of health or the Department of Public Health, depending upon jurisdiction.
PC, go ahead.
Thank you, Acting Chair. And I just wanted to, well, I have two different points, but on this topic, I just wanted to make I guess a question for clarity on it. It was my understanding though that for any prepared foods at a social consumption establishment, just because while we're talking about prepackaged foods here, social consumption establishments, they can prepare food as well. It was my understanding that that was entirely under the jurisdiction of DPH and that we would not be enforcing or necessarily monitoring compliance with that aspect of those businesses. It's my understanding that that's kind of where that jurisdictional divide is. So while we're kind of having this conversation, I just wanted to throw that out there.
That's correct.
And then when it's appropriate too, I wanted to just ask another clarifying question on shelf stable food products and the definition that we have and how, just because it is a defined term, I just want to make sure that we have some clarity there. But if we're continuing on this conversation, I can raise that when appropriate.
Is there a question about it in this part on page 93 that we're talking about in terms of you want clarity on shelf stable
Yes,
products?
yes.
Okay.
Okay, so just in this section, while we're looking at on page 93 under section 3, E, we're just identifying that a marijuana establishment may sell non-infused food and drink items that are prepackaged and shelf stable. So shelf stable here is capitalized because it is a defined term as Director Enos was talking about earlier. When we're looking at the definition of shelf stable, I understand that DGC Baker did make some edits to this, like striking the phrase as defined in the appropriate DPH CMRs. He changed that to adopted, which I agree with because time temperature controlled for safety food is not defined. So I just wanted to highlight in here and offer a suggestion that we might be able to simplify that definition of shelf stable as well, because right here, so, and sorry, if you'll just indulge for 1 second, because I went on a little expedition to try to figure out what was going on with this quoted language here. So it appears that time temperature controlled for safety food was a defined term. It is not defined in there in the 105 CMR 590 anymore. But what this is saying is it is food that is subject to time and temperature controls in order to ensure the safety of that food. So what I would suggest in here is perhaps deviating from that. But I would suggest eliminating the quotation marks because it is not a defined term in the other CMRs. I would also suggest maybe spelling this out in a more straightforward manner so it's easier to understand, that we can say shelf stable does not include foods that must have certain time or temperature controls to ensure the safety of those foods. So in essence, it is safe to consume while it is being stored at room temperature. And I know there are some questions too in terms of would licensees be allowed to have vending machines, or is this something that they're going to need to purchase at the actual point of sale? There are specific regulations that I was also seeing in the in 105 CMR 590 that are related or specific to vending machines, so that could potentially complicate it as well. But I believe that Deputy General Counsel also, I know he has a connection with counsel over at DPH too. So I kind of just want to highlight these points so that we can get clarification as we're moving forward, if this is the intention of the board to allow this, so that we can, one, make these standards legible and clear for everybody involved, internally, externally, for members of the public, patients and consumers, but also just it candidly took me a little while to figure out what does time temperature controlled for safety food mean, just because that's a bit of a confusing phrase in my opinion, and then also it's not a defined term at all. So I had to piece together a few different regulations and utilize context clues there to actually understand what that was designating. It's simple once I put it all together, but just we can save somebody else the work.
Thank you, Acting Chair. Attorney Gooden, thank you for flagging that. Your flag just generated a few things in my mind as well, because we also don't include a definition for prepackaged either. And the way that we have this constructed now as the draft is, technically a licensee could create their own shelf-stable items and sell them. There's nothing in here that would require that it go through a different process and be, a bag of chips from a manufacturer or whatever that gets into these licensees and establishments. The way we have it written here could be shelf-stable from any source.
I'm not sure. I don't read it that way in so much as 105 CMR 590 is cited, so they'd have to at least be compliant with the DPH regulation there.
Attorney Baker, do you mind expanding more about what the DPH, just expand more on the stipulations and the requirements that would cover this? I just want to make sure I land where you are.
Sure. It wouldn't, or time and temperature control, they'd still have to be compliant with this regulation of 105 DPH. So all I'm saying is that that would be under the local board of health or DPH jurisdiction to enforce if there was an issue with any of their regulations.
I don't know if that gets to what I'm saying though.
Sorry.
I'm saying that we're not permitting licensees to create their own food, right? Their own shelf-stable items for sale.
Right.
And your response was DPH has something that already restricts that.
Commissioner.
Yeah.
I'm obviously less familiar with DPH's regulations than I am with ours here, but I think that they would end up becoming a commercial kitchen if they put it out for public sales of their own made goods that they consider to be deemed shelf stable. So I think at some point they are running afoul of DPHs and local boards of health if they tried to go down that hypothetical route.
So you're saying in either way they would cross,
Yeah, sorry, I misunderstood your point before.
I think I'll need more time with this. I don't think just because there's a lot of different factors that we need to consider. But I'm open to, you Acting Chair and Commissioner Roy, what your thoughts are on this.
Yeah, and I mean, to me, it sounds like clarifying some definition work. And the other topic under E is, do we want to limit it to marijuana, retailer marijuana, social consumption establishment, marijuana delivery operator, just in terms of language of who would be able to sell these? So kind of two questions I want to resolve.
And then just briefly, we are speaking with DPH as we're rolling these out, and we will be getting their guidance or comments once we put it out for public comment. So we've been trying to work with them throughout this process, but I will especially want to make sure that they're okay or comfortable with what we're putting out relative to this.
Sure.
Depending where we land, I just want to flag this, recording sales, which we speak to in 500 145G and we speak to in 500 146 4F, separate point of sale for non-marijuana products. So I just want to flag that depending on where we land, we might need to incorporate language because that only speaks to a retailer and a delivery operator about a separate point of sale. So I just flagging that where we land, we might need point of sale language.
Council Chair.
Yes.
You also said something earlier that raised another flag when you spoke about access, sort of sharing access to restricted areas. And that still is something that's I'm mulling as well in terms of storage when there are shelf stable items, because we want to make sure that we maintain limited access to areas that are holding and storing cannabis products. If there needs to be any sort of separate storage facility for those shelf stable items so that there aren't too many people going to these restricted areas, especially people who are not agents or employees of Cannabis Control Commission.
Oh, and are you thinking a provision where shall not be stored in limited access areas, some language, something to that effect?
Yes.
Okay.
A concern, Acting Chair, if I may. I think there's a lot of different components to this. And they're coming as we're talking here. So I feel like you know, I know we'll eventually land on something today. We'll probably have another conversation, but I just feel like there's some more considerations that probably need to be put on the table as well.
Thinking of everyone, a delivery operator, item their vault is still a
Limited access area.
limited access area.
Mhm.
Don't forget, we did start with just retailers. So we could end up back just in retailers.
We could. Okay.
One more thought.
Go ahead.
Sorry.
Add it.
One more thought, just because Attorney Baker raised another point when we were talking about DPH, and if they wanted to go through this entire thing and sell shelf stable items the correct way through DPH's blessing, I just also wonder then. I'm just wondering about the separation things. I'm just really wondering about that separation, and our team here has raised it, just making sure that that we don't become responsible for items that we do not regulate.
But we're mandating it, social consumption. We're mandating they carry it. Shall, not may.
My understanding is that DPH doesn't regulate shelf stable items.
No, but I can share. I saw Director Pinkowski's, yeah, just in response to you. When we were talking about, this may or may not happen, but as written, the way that our regs are drafted, if a licensee wanted to sell their own shelf stable items, there's a process that they would go through in accordance with DPH. And so I guess I'm speaking to one like very specific scenario that they would license that. They would give permission for someone to do that.
They would have to go through commercial kitchen requirements in order for them to do that, to sell to the public, which isn't necessarily what we're talking about here. But again, I'm less familiar with these regs than I am our own, so I will double check with DPH's counsel.
I hear you. I think whenever we do regs, and this is, okay, you come from the State House, you know, you think about statutory changes and what that might do inadvertently. So my mind sort of goes all around to make sure we're not doing something that then creates another thing that was not intended. And you probably notice this whenever I'm talking, I start thinking about all the possible scenarios because that's usually what happens with statutes.
Director.
Thank you. I was just going to point out that for the social consumption, it's that they shall have access to food. So there's going to be licensees that choose to, I think it's been discussed, have Uber Eats come in, or they have food delivered to it, not necessarily hold it within their facility.
What I'd like to suggest, and obviously, I have a feeling we're gonna be meeting tomorrow, we can kind of set this, add this to topics to revisit tomorrow. Obviously, we've had some changes. Marijuana establishment shall see all licenses and permits as necessary prior to the sale of shelf-stable products, so I added that. And then obviously, I think we need to look at the shelf-stable definition. I also think we need to decide whether we're going to include whether it's strictly just going to be for retailers and delivery operators, retail delivery operators, and social consumption establishments, even though their piece is, I think, caught up in 141. Unless there are any other thoughts. Now we can move on. Of course, go ahead.
Quickly, I think the topic of allergens, I know, our director of enforcement training did bring it up. It's something for the board to think about because we are very, within our regulations, we are prescriptive in terms of what the labeling requirements are related to allergens. So keeping in mind that if the board does move forward with allowing shelf stable and somebody has an allergic reaction, I know what has been said here that, TPH would have a site, but again, I think I heard where there is a assertion that was made that if it's shelf stable, TPH wouldn't have oversight. So if somebody had an allergic reaction and they purchased the product in one of our retailers, what happens?
Deputy GC, did you have anything else that you wanted to? Anything else that you want to cover? Till we get to, I have some other points just picking up on page 99 where I know we're well into 141, but.
Just to summarize the conversation, so again, we're gonna look at the definition and potentially tweak that. We're gonna look at MEs and whether that's the proper term of art here, or retailers, or listing the licensees. And taking a look more holistically at shelf stable in the context of E. So I think those are the three takeaways that I have from this section. Is there anything else from the board?
Commissioner Roy?
Deputy General Counsel, just like a cursory search, reporting of allergic reaction to a shelf-stable food in Massachusetts. You would contact your local health department. You can report the incident to the local health department in the town where the food was purchased or consumed. The Massachusetts Department of Public Health Food Protection Program. The Massachusetts Department of Public Health Food Protection Program can be reached at or email. And you may also contact the Massachusetts Department of Public Health Epidemiology Program. So there are avenues to report an allergic reaction to a shelf-stable food item in Massachusetts.
If I may, Commissioner One,
Mhm.
Acting Chair, if I may.
Of course.
I think that then that's why it would be helpful to either include that or through guidance somewhere so that consumers are well aware. But one of the sections you read there, Commissioner Roy, one of the things that they look into is to see where the product was purchased. So how does that remove us out of the equation if they purchased it from a retailer?
Okay.
The information to have on hand when reporting is details about the allergic reaction, including symptoms and their severity, the name and brand of the food product, the date and location of the purchase, and any remaining food product or packaging, and your contact information. So all of that information would be required.
It doesn't, yeah. I hear your concern.
Chair, if I may.
Go ahead, Director.
Yeah, not to belabor the point, but just picking up on Chief Jones and Commissioner Roy's points, I'm just imagining a situation if someone has 5 or 6 different shelf-stable items that day, and then they get violently ill or sick, paramedics are called, what did you eat? Oh, I had these 5 things. Now, are we then going to be asked to some degree to now identify which of the 5 prepackaged items made this person sick? That is not within our jurisdiction. That's obviously going to have to be done with other experts there. And again, if there's a larger problem with any of these products at a production level, it's just potentially opening us up for a lot of additional work that I don't know if we'll have the answers for right in the moment. We can work on there. But that example, again, one person having 5 different products in one night, I get very sick. How do we know which one of them it was that made him sick? Then how do we as a CCC identify that ourselves?
Or if it was a cannabis product.
Or if it was a cannabis product or a combination of them all together.
Commissioner Walker.
So reading the draft regulations, a social consumption establishment shall sell non-infused food, water, and drink items that are prepackaged and shelf stable. So we're gonna have to deal with it somehow. I mean, I understand, I hear all that, I do. And I'm very sensitive to all of it, but it's gonna be mandated that they carry shelf stable, so.
No, yes, Commissioner, understood. I think this kind of ties in, I think, to my initial point about, again, if we were talking exclusively about social consumption establishments, that's a much smaller number, as opposed to where we're potentially, the board is going, where it's all retailers and potentially other licensees. That number quickly balloons up a lot more. And obviously retailers are plentiful right now. There are a lot of them out there right now. So obviously it's for the board's consideration, but just bringing that up because that will be a factor where I don't think it's if, but probably a matter, unfortunately, of when, if it does happen, how will we then respond? These are just some of my initial kind of concerns and thoughts that are popping up if we expand it beyond social consumption establishments.
Go ahead, ED.
Just high level again, going back, I think, through a formal comment period, depending on which direction the commissioners would like to start, I think you'll receive comment from right. If you start with just social consumption, you'll receive comments that why not, and there may be compelling arguments on either side of that. And if you start more broadly, we may see from whether it be municipalities that we talked about earlier or other business associations that don't want these businesses competing, you may hear those compelling. So I don't know that, not to, remove the importance of the discussion right now, but I think you will receive feedback either way you go.
One more thought, just while we're mulling this over, because by including a definition for shelf-stable items, I believe that means that it falls under our purview to review and make sure that the items that are for sale are in fact shelf-stable. So we are that, like, I see the overlap into our team here to go beyond the scope of cannabis and beyond cannabis products. So I think I'm having some reservations just because we're now going beyond the scope. And I also was wondering about, okay, if a shelf-stable item, there's some issue with it. And it's been sold knowingly or intentionally by a licensee. Are we then issuing an enforcement action, even though this product is not being licensed? Or it gets murky. So I say that to say I'm at a place right now where have not landed. I just need to sort of mull this over a little bit more.
May I ask Commissioner Concepcion, in light of that, are you leaning towards removing it on a social consumption?
No, but I hear Director Enos, I hear his comment about expanding the universe and what that might actually do, like understanding what that then does to our own resources here and just seeing where the responsibilities lie. It gets more complicated the broader we are. So I'm going through the thoughts right now. I can try to see.
Deputy J.C., go ahead.
Just to push back a little bit here, there are other agencies that will handle issues that are brought to light through this. So if it's the local Board of Health jurisdiction, then they're going to be the one to step in if there is an issue.
Yeah.
Similarly, we don't really police the marijuana accessories as much as we would police the marijuana and marijuana products. Are we looking at every item that is being sold as an accessory? Question to enforcement. Where, I think in a similar way, it's not really as the shelf stable food that is being sold there is not under enforcement's purview to double check on. Like it is.
But if
for
we're
marijuana
defining
products.
who's making the determination? You know what I mean? If we're defining what shelf stable is, who makes the determination that what's being sold? Because if it's not shelf stable, then you're in violation of our regulations.
That's why we're cross-referencing the other regulation.
Commissioner Roy.
Do any of our retailers sell soaps? Bars of soap?
To my knowledge.
None of them sell soap?
I didn't get,
Okay.
maybe they do, but was.
Candles? Okay.
As a follow-up. So from your understanding, if we're having the cross-reference, then that brings us outside of our enforcement team. Is that? I'm understanding it.
Sorry, I see some faces being made from enforcement council, so please.
Go ahead.
Comment.
Thank you, Acting Chair. And I mean, thank you for the discussion just overall, because I think it's very interesting that the conversation here has kind of come full circle to the conversation that the initial cohort of commissioners have had. So in going back and kind of reviewing the meetings that they had and they've discussed in these areas, I know some of the initial cohort of commissioners, their ultimate consideration or concern with allowing the sale of additional items like food, et cetera, was because they didn't, and I believe the quote specifically was from Commissioner McBride, said that she did not want, or her intent was not to have our investigators become Uber investigators and be responsible for policing different regulations or different items that are outside of our general purview. So I know that the original cohort of commissioners had the understanding that, or their understanding rather, was that MEs or our licensees were limited to products that we actually regulate for sale in stores. So that was expanded to branded goods, accessories, I believe, have always been allowed, et cetera. But it does, Commissioner Concepcion, to your point, it does kind of start to blur the lines a bit. And I think from a general policy perspective, if we're adding these sorts of things in, I think to the points that my colleagues raised in terms of their concerns or other considerations rather, it's more so just in terms of what kind of guidance is the board offering to the staff when we are actually going out and inspecting these places, bringing enforcement actions? Are these items that we want to just turn a blind eye to and not touch on, which I think could just practically be a little complicated, because if there is an item in a marijuana establishment that is offensive in one way or the other in terms of like it gets somebody sick or it kind of crosses a line for a local board of health, et cetera, we are generally one of the first places that other jurisdictions will reach to because it relates to a marijuana establishment. We are the ultimate regulating authority there for those businesses in this state. So I think that's why this was not incorporated previously. I'm speculating, obviously, but based on the kind of context that I have seen in prior meetings, that is what stopped the original board from kind of making these further allowances. Now, is there space to do that? I think obviously that's up to your discretion, but there are kind of these additional factors that I think do need to be weighed before we kind of grant this, which just as one point, I would say that I think the inclusion of subsection D or clause D under subsection 3 here that specifically states that unless otherwise authorized, a marijuana establishment is limited to selling marijuana products, branded goods, and accessories. Because those are directly within our jurisdiction. I understand too that with social consumption that this conversation necessarily has to happen, but this is one of those more complicated areas because we are blending jurisdictions here between.
And I understand that. Right. Just and I appreciate the kind of history, right? And it was more important to get establishments open than necessarily think of every opportunity under the sun. You know, we're kind of at a point where the industry is a little more mature. The industry has approached us about this, and certainly as it's been raised, you know, we do want to make it a component of social consumption. One for public health or public safety benefit. But we have an agreement with any of our dispensaries can sell hemp products. What happens if I buy a hemp product and I have an awful reaction to it? Who does the hemp product complaint get raised? How it does?
Correct. Yeah. So acting chair, in response to that, the MDAR has primary jurisdiction over hemp. And so we do have, there is a joint bulletin, I believe, that specifically goes to that and provides guidance for these regulators. And we have communicated and collaborated with MDAR on a number of different occasions when it comes to either hemp non-compliance and them reaching out to us to get access to certain facilities, and also vice versa. And I know that it was either last year or actually I think it was the year before, there were issues with hemp-derived beverages or beverages that had hemp-derived THC, and that honestly was kind of a complicated situation that dealt with MDAR's jurisdiction, DPH's jurisdiction, the ABCC's jurisdiction, and the Cannabis Control Commission's jurisdiction. So do understand that there is legislation that is being considered, but I think all of those kind of past issues that we learned as it related to that, those beverages, and it did require from my understanding, really intensive coordination and collaboration between all of those agencies to one, even determine who has ultimate jurisdiction over this, and then actually deal with the issue of those hemp-derived beverages in, I believe it was like restaurants, liquor stores, gas stations, et cetera. So.
Thank you. You stole my thunder, but I'm going to echo on it. And we allow consumer-ready hemp products, as acting chair just said, hemp seed powder, hemp protein. And so we have an MOU or something with MDAR. So what would prevent us from requiring SOP reporting for these retailers, how they handle, you know, allergies or reporting allergies, or like we don't regulate hemp, but we allow consumer-ready hemp products, protein, seed powder. So there's precedent here. It might not be apples to apples, but it's not that far off.
Yeah, acting chair, if I may, and
Of course.
but I mean, Commissioner Wright, I would definitely defer over to the legal department, the executive director, in terms of what the board would want to do, or kind of where those ultimate bounds are. However, I think you're raising a really good point here. And the difference, I think, is that we already have that established relationship with MDAR, and the understanding, or the staffs have kind of an understanding in terms of what does the decision tree look like? How do we respond to those sorts of situations? This is brand new for us. So in order to actually address some of the potential issues that we're discussing today, we would just need to engage with DPH, figure out how that relationship ought to work. What is that order of operations, which I know that it is like DGC Baker already has one contact over there, but we would really need to significantly expand that relationship in order to address these different potentialities that could come up as businesses start to sell or start to venture into that space. So I think you're bringing up a good point, and I think that it's not necessarily something that can't be overcome, but there's a lot of additional details that need to be considered before I think we're ready to move forward with that.
Just thank you, PC, good, Deputy General Counsel. The timeline. So the timeline, here we sit in almost the end of July, is gonna go for public comment. What do you envision the promulgation in October, November?
It would depend on when we live.
Approximately, but we'll get to it.
Right now, we're on the cusp of both.
Okay.
End of October, early November, if we delay any further.
Okay, so that there's some time built in there. Not gonna happen, even if we landed on, yes, retailers, it's not happening tomorrow. It's not gonna happen until the earliest, probably the end of October, beginning of November. But in the meantime, I understand the need to reach out to, I understand the need to reach out to DPH, like you did with MDR, and come to some sort of understanding of how, what this would look like. But even if we landed on it, it's still months off. Okay, thank you.
Commissioner Concepcion, I'll give you the
Thank you.
last word, and if we want to jump into some other stuff before you
Thank
get to the end of the day.
Attorney Gooden, you jogged something, and it was something, so understanding that municipalities have their own entities. And DPH, as Attorney Baker has also stated, would not be that entity because it's more local. I think, I just wonder if there is we can bake in something that's similar to the MOU process that we have, maybe that licensees go through when they're developing an HCA to make sure there's an agreement made prior to. So it's another idea. I'm really concerned about who is responsible and making sure that we're not just saying out in the air, we're not responsible, but somebody needs to be the responsible party. So identifying that and making that a requirement prior to allowing shelf-stable items to be sold. Because I just think we're falling into a really dangerous, delicate situation if nobody holds responsibility.
Chief, go ahead.
If I may add to that, Commissioner Concepcion, that's really what we need to do. That needs to be defined from the beginning where it's very clear. And you're right, with the definition of shelf stable, our inspectors, I heard the mention about accessories. When they walk in, they can see that, okay, these are accessories, these are branded goods. And then in this instance, once we have a definition as it's, written here, the expectation will be that they look into those shelf stable products. And then there's no way we can remove ourselves from it once we have the definition within the regs. And then I can see instances that if they do find that it's not, we'll be the ones issuing the NODs and all that. So we cannot completely, it will be difficult the way that it's written for us to be completely removed from the process. And then if DPH is already saying they don't oversee shelf stable, that it's very important for us, to figure out how this will talk to the food inspectors, and whoever else we need to talk to, because even with the local board of health, one of the things that we've seen that we've encountered at all times, even with auto mitigation and things like that, it gets very tricky in terms of, the extent of their involvement. When we have auto mitigation complaints, we still receive those complaints. They still require us to be responsive to them, even though the local board of health are involved. And even in instances where we had other investigations where it starts with the local board of health, they still look to us, and then we end up having to be the ones to be more involved in there. So that's another thing that I think we need to, you are right, that needs to be ironed out beforehand, whether it's for all license types or whether it's for social consumption. It's something that we need to work out so that walking in, it's very clear. And then when we provide the guidance documents or whatever we do at that point, we're being very, detailed in terms of how that would work, so that people know what to reach out to when they encounter these issues or these problems. Because we already know from what we're talking about here today that it will not be the CCC, right? But at the same time, we need to, direct them in the right path.
I guess where I'm coming down for purposes of discussion today, I'm happy to pick this conversation up tomorrow. Happy to think through, addressing this first, well, a couple of different topics. Who are we going to allow? Is it just marijuana retailers, social consumption, delivery operators? Looking at whether we need to include a definition, even though the definition is we currently have it written, certainly cites standards set by DPH under their regs. And then I'm willing to, again, coming back to this as a draft, putting it out for public comment, giving, the Department of Public Health, any local boards of public health, the opportunity to comment and weigh in on as well. But I hope that's okay where we can kind of leave it today. Go ahead.
No, stop.
Okay. Real quickly, I just want to get to a couple of other points I want to raise, and then we're deep into 141. Couple of changes I had asked for us to make page 99. Starting the transportation plan, which I think is K. Giving some thought to what we had previously said, hey, get a plan that's tailored to the region. My recommendation is to add new language which says such requirements shall be tailored to the host community and region, which is the social consumption. Oh, sorry.
There.
Oh, yeah, I'm sorry. Such requirements, second sentence under K, such requirements shall be tailored to the host community and region in which the social consumption establishment is located and reviewed for comments by the municipality's chief law enforcement officer. Kind of adding that detail to it, again, not for local law enforcement to have a veto over a plan, but to have the opportunity to offer comment to the plan before it's submitted to us. And then, go ahead, Enforcement Council.
Thank you, Acting Chair. And just one potential suggestion here. This seems very similar to kind of alternative security provision language, which so in those instances, this is really more on the commission side of things, but the commission will reach out to the chief law enforcement officer. And there is a certain time period where the chief law enforcement officer can provide feedback, either approve or not of the alternative plan. So this seems somewhat similar to that. I'm wondering if it might be appropriate to just tweak this slightly to add in information in terms of what if the chief law enforcement officer does not provide comment or feedback on that plan, what process has to be taken. And I know in the alternative security provision space, just for edification, if the chief law enforcement officer does not respond within, I believe it's 30 days, then the commission will just move forward regardless. And also the with regard to ASPs, the commission takes those under advisement, but it is not a veto. It is not authoritative necessarily, but we will generally take those under advisement. So I'm just wondering in this circumstance as well, whether it would be the board's expectation that the social consumption establishment would incorporate any comments by the chief law enforcement officer, or if they ought to take them under advisement or ought to provide them to the commission, something along those lines. Just what must be done with those comments and how do we move forward if the chief law enforcement officer does not respond in those circumstances. So just a bit of feedback there.
Yeah, so if I may add,
ahead,
Madam Chair. So in addition to that, not just, the responsive part of it, but also if it's a situation where they have commentary in there that, in a way they do not agree, what does the board want to see? I think that would be helpful because what we foresee in those instances where they're not, on the same page, if the chief law enforcement officer is saying one thing, that could create other, issues whereby they say, okay, how did you move forward with this if the chief law enforcement officer is saying no, right?
Right.
So they could say, okay, he's seeing that, for example, they're expressing that as a public safety concern.
Yeah.
And then how is the commission moving forward, even with that commentary? So,
It exposes us.
yes.
Yeah.
It's a good one.
Other item, I just had two other changes under this.
I just want to, where do we land there? Do we eliminate for comments? 'Cause I would just, if someone hasn't thrown that out, I would just eliminate the term for comments.
Should say review file.
Because that's similar to our security plans. They require that to be submitted and available to local law enforcement. So we would still require a review, but not the comments.
Okay.
Chief Jones has.
Yes, that sounds good.
Yeah.
Yeah, just the review. Without saying, for comments, because those comments, again, it's not something that we can then ignore. If that, if they raise concerns, right? Mhm.
But do you have that change? Or do you have thoughts on it?
Yeah, thanks. So is it just provided rather than review? Because are we gonna ensure that they review it? Or just give notice, basically is how I'm reading it, but.
Well, I think we need to come back to this one tomorrow. I do want to go look at the sections of return. Reviewing alternative security plans, see if we can kind of align that language. But definitely dropping the comment period out of it, or the comments. Go ahead.
Acting Chair, just for your reference, alternative security provisions are under 500-110 subsection 2. And the submission to the chief law enforcement officer, what we ask is for them to certify the sufficiency of the requested alternative security provision or provide the commission with a statement of reasons why the alternative security provision is not sufficient in the opinion of the chief law enforcement officer. And then the commission takes the chief law enforcement officer's opinion under consideration when determining whether to grant the ASP. So just some additional.
So there's some provisos there to get us out of the liability bit. Liability.
Yes, we say we will take it into consideration, but yeah, it's.
Yeah.
That's just what I'm suggesting. If we want to look at that.
Quickly, the other two areas I have. Further down on 99 with respect to, this is under P4. We're talking about the negative air pressure ventilation system. I would only, and I can drop this into the chat for everybody's consideration. I would like to also incorporate a level of identifying a level of filter that we want them to use in their filtration system. Both through homework to look at OSHA, but there is what there is called a minimum efficiency reporting value on a filter. And I would prefer not to see a filter with a rating not less than 13. That seems to be the level by which smoke can also be eliminated. That in the chat, and then one other. Quickly becoming an expert between the OSHA sites and ASHRAE. And then the other one is on page 105. This is under the section around cool down area. Removing the word under 12C, removing the word tap. I don't really care how they get their water to a consumer. I mean, it's just changing it to water. I don't care whether it's tap or bottled or what have you. Commissioner Roy, go ahead.
So I have a proposal for the pull down space, but I think it's best served tomorrow because this kind of could be a lengthy discussion.
Okay.
Before, Madam Chair, before we go further, for the definition for a negative air pressure, I see that the language was already in there, inadequate to mitigate odor at the property line. I'm thinking about our odor complaints. I don't know if we really need to, the board probably needs to think about the use of the term adequate, because we had instances with the licensee is, contending that they have ventilation systems that are adequate enough to mitigate the odor, but still, there's still some odor and all that. So maybe that's something for the board to consider as we're going through this regulation. Regulatory amendments or changes to see if we still need to have adequate, because it's very broad or open-ended and it's very subjective.
Okay. And some of that may be helped by being a little more prescriptive as to what level of filter we want them to use. I mean, the level 13 is suitable for hospital inpatient, general surgery, and smoke removal. There, and these MERV levels go up 1 to 16. So again, more than I wanted to learn. Go ahead, guys. Go ahead.
Thank you. I know we're nearing the end of the day and we're picking back up in the morning, but one of the flags that I was hoping to get across to you all today is under 141.2B, we have labeling requirements that are supplemental to what is already required at retail. And I'm just flagging for you all. I'm hoping to get your review from it to see if it makes sense to you. We had reduced what was in there beforehand, but to not be duplicative of the current requirements. But again, we're going to be picking the discussion back up in this section, and it would be really helpful to have your eyes on it before the discussion tomorrow. And then just in general, I do want to offer a number of amendments in 141.3, which is, we're just before there right now. So I'm hoping that that language does get amended, and I can offer those in an email to you all if that makes sense tonight. So you have an opportunity to look at it before the discussion tomorrow. But again, just wanted to say that before we wrapped.
Commissioner.
Deputy General Counsel, you first flagged 141.2B. What was the second citation you said?
141.3, limitations on sales. We go through edibles, MIPs, even shelf stable and other foods. So that is where I'd like to spend some more time tomorrow shoring that section up. And like I said, legal had reviewed the draft after it had been sent, and we have a couple of different ways that we want to mark up that section. So I will provide that to tease it for the discussion tomorrow.
We're at 4:54. Thank my colleagues, thank our team. We got through a lot of discussion, getting super granular, which is important. We'll pick it up tomorrow. We will be remote. I'm looking at a few things I need to focus on. You had talked about the working on the transporter license alignment. Again, some of that we might have to do in real time tomorrow. And obviously picking up any other thoughts that you all have with respect to fundraising. I want to go through those tomorrow and again, hopefully get us to a place where we can vote to approve a draft to put it out and make the publishing deadline of Friday. But Commissioner,
I would respectfully just ask for time around page 104, 105 pull down requirement.
sure. Yep.
And Chair, I have a request of our executive director, because I know your background is with municipalities and working with them. When we were talking about shelf stable items, wanted to understand sort of the utility of MOUs if it makes sense to have a requirement there, or, you know, sort of where this may land, it makes the most sense for an agreement that's required between a licensee and municipalities that oversee food products. I already told Attorney Baker, I'm happy to, you know, talk with him and work with him more, but I think that it'll be helpful to hear your perspective.
I will take a look at that. Thank you.
Anything else from our team? Thank you all. Greatly appreciated. Again, we'll pick this up tomorrow morning at 10 a.m. We'll be remote. Commissioners or team members, any closing thoughts or any comments? Thank you all. Greatly appreciate it. Again, there you see July 29th, public meeting will be necessary, remote via Teams. And then you see the other dates of our upcoming public meetings, 14th, September 11th, September 23, and dates into October and November. Those do not include any sessions at this point that we'll have with respect to a public hearing for the promulgation of these regs, or sessions to kind of go through, work through the comments after legal has had a chance to review them, and obviously proceed with the formal votes to officially adopt. Commissioner Roy, go ahead.
If possible tomorrow, I would also like to revisit the badging language we land on in light of the new information provided from Director Koval and team about the outdoor cultivators.
Okay. All right. All right. If there's nothing else, I would entertain a motion to adjourn. Do I have such a motion, Commissioner Concepcion?
So moved.
Do I have a second, Commissioner Roy?
Second.
Motion been made and seconded. Any further comments or discussion? Seeing none, do a roll call vote. Commissioner Concepcion.
Aye.
Commissioner Roy.
Aye.
And Commissioner Stephens votes aye. 3 in favor, none opposed. We are adjourned.
Oh, my goodness.